decided to just start the program because we are having a considerable number of people online who we can't keep waiting. Ladies and gentlemen, like introduced earlier on, I'm Aziz Chitaka, a member at AdLegal, and we welcome you all at the first Big Tech Accountability Summit, which we have convened in partnership with several partners in Uganda and around the continent. Ladies and gentlemen, why the Big Tech Accountability Summit and its theme being focused on data privacy and competition? As AdLegal, we scanned through the entire continent and realized that the main issues which are pertinent on issues which touch big tech accountability in Africa, they are mainly two: data privacy and protection, as well as competition. And with this, we have seen several investigations and decisions which have been delivered by different regulators around the continent. And we saw the first coming through from Nigeria, which did the very first investigation against Meta, and it penalized Meta heavily. From that investigation, different kinds of investigations and litigations arose. And as AdLegal, we also took up a complaint at the Data Privacy and Protection Office, which also delivered its position on that. Ladies and gentlemen, I'm also proud to say that AdLegal was the first, it is the first entity to institute a complaint in regards to the new COMESA competition regulations, which regulate digital markets. And that was against Meta, which the COMESA Competition Commission found a prima facie case. And a lot of investigations have been happening, but I won't delve into that so much because our panelists, which we have aligned from the different countries, including regulators and practitioners, will be talking about that in detail. So, ladies and gentlemen, this summit is going to run for 2 days. The first day touching data privacy, and then the second day touching competition. We have aligned several speakers, and every speaker who is going to be participating in this summit has something to add, or they have done quite some work in these areas. We have made it a bit extensive by getting speakers who are not Africans, but who have litigated these matters, who have developed policies, and several other things which touch on big tech. Ladies and gentlemen, I would also like to point out to all of us that this summit is not only about big tech, but it is about the digital economy as it is. The issues which affect Meta, the issues which affect Google are the same issues which can cause legal challenges to other digital markets. For example, in Uganda, safe border, fintechs like MTN Mobile Money and so on, they can also be subject to these kinds of issues. So, ladies and gentlemen, we welcome you, and we thank you all for participating in this summit. And without any delay, allow me invite the Solicitor General of Uganda, who is representing the Attorney General, Mr. Charles Ouma, to come and give us the opening remarks for the summit, from which the summit will be officially opened, and we shall delve into the different panel discussions. Thank you so much.
Thank you, Aziz. Good morning. Yesterday, when I was doing a follow-up call with Luke, who's been organizing this, I think on behalf of Adligo, he later on sent me a brief on the program. And on line 3, I noted that I had been referred to as Mr. Charles Auma. For the record, Auma is feminine for Ouma. And I also like to confirm that my pronoun is he. It's not he, she. So just to open that statement with regard to the function that we are attending today. But I'm privileged to be in attendance today, ladies and gentlemen. You'll excuse me, I won't be joining you for the rest of the day and tomorrow, but we are very grateful that we have been invited as the Ministry of Justice and Constitutional Affairs, and in particular the Attorney General, to address you today. So it's an honor to address this summit on big tech accountability, data governance, competition policy, and artificial intelligence governance in Africa's digital economy. I wish to commend the organizers for convening this important platform at a time when governments across the world are increasingly confronted with the growing influence of multinational technology companies, rapid expansion of artificial intelligence systems, cross-border data ecosystems, and evolving digital markets. The theme of this summit, Legal and Policy Frameworks on Big Tech Accountability, Data Protection, and Artificial Intelligence Governance in Uganda, is both timely and necessary. Across Africa, digital technologies are rapidly transforming communication, commerce, financial services, healthcare, education, governance, agriculture, labor markets, and public administration. Artificial intelligence systems, digital platforms, cloud infrastructure, e-commerce systems, fintech ecosystems, and cross-border digital services are increasingly becoming central to economic growth and modern governance. However, these developments have equally introduced significant legal and regulatory challenges relating to data protection, digital surveillance, online harms, misinformation, cybersecurity, platform accountability, competition within digital markets, artificial intelligence, governance, and cross-border enforcement. Today, I'll focus on a couple of things: the current state of big tech regulation and digital governance within Africa. 2, data protection, cross-border data governance, and digital sovereignty within the evolving digital economy. Competition law, concerns arising from concentration of digital power and dominance within digital markets. Artificial intelligence governance and regulation of emerging technologies. Comparative international approaches towards regulation of digital platforms and digital markets. And actionable policy and regulatory measures necessary to strengthen accountability, consumer protection, innovation, and public trust within Africa's digital ecosystem. Now, so what's the current state of big tech regulation and digital governance in Africa? Across Africa, governments are increasingly confronted with the growing influence of multinational technology companies operating digital platforms, social communication systems, e-commerce platforms, cloud infrastructure, digital advertising systems, and cross-border digital services. Companies such as Google, Meta Platforms, Amazon, Apple, the companies behind TikTok, X, and other multinational technology companies, continue exercising enormous influence over digital infrastructure, online communication, and data ecosystems and digital markets globally. The increasing concentration of digital power within a small number of multinational technology companies has generated growing concerns regarding platform accountability, market dominance, exploitative digital practices, online harms, consumer protection, misuse of personal data, and regulatory oversight within rapidly evolving digital economies. Data protection, cross-border data governance, and digital sovereignty. One of the key discussion areas at this summit is data protection and privacy. Uganda's data protection framework derives constitutional foundation from Article 27 of the Constitution of the Republic of Uganda, which guarantees the right to privacy. This framework is operationalized through Data Protection and Privacy Act, CAP 97, and Data Protection and Privacy Regulations 2021. Uganda equally established the Personal Data Protection Office to oversee implementation and enforcement of the country's legal framework governing personal data and privacy. Importantly, Uganda's legal framework applies not only to entities operating within Uganda, but also to persons and companies outside Uganda who collect or process personal data relating to Ugandan citizens and residents. This extraterritorial application is particularly relevant in relation to multinational technology companies and digital platforms operating across multiple jurisdictions. Section 3 of the Data Protection and Privacy Act requires persons processing personal data to ensure accountability, fairness, lawful processing, transparency, and protection of data subject rights. Section 7 regulates collection and processing of personal data, while Section 19 governs cross-border transfer of personal data outside Uganda. These provisions have become increasingly important in an era where digital platforms collect, process, analyze, transfer, and monetize enormous volumes of personal data generated by millions of users every day. Uganda's data protection framework has increasingly been applied to multinational technology companies operating digital platforms across jurisdictions. In matters such as Frank Sekama versus Google LLC and AdLegal International Limited versus WhatsApp LLC and Meta Platforms Incorporated, the Personal Data Protection Office considered issues relating to lawful processing of personal data, transparency obligations, user content, platform accountability, and cross-border transfer of personal data by multinational digital platforms operating within Uganda. These developments demonstrate Uganda's growing commitment towards strengthening accountability of digital platforms and protection of personal data within the evolving digital economy. For African states, these concerns are particularly significant because many multinational technology companies continue operating beyond territorial borders, while influencing domestic economies, public discourse, and social interactions within African jurisdictions. This raises important concerns regarding accountability, jurisdiction, enforcement mechanisms, and digital sovereignty. Comparatively, courts and regulators globally are increasingly strengthening accountability of digital platforms. In Google Spain SL, Google Inc. versus Agencia Española de Protección de Datos and Mario Costea González, the Court of Justice of the European Union recognized that operators of digital platforms bear responsibility for processing personal data within digital ecosystems. Similarly, in Carpenter versus United States, the Supreme Court of the United States recognized the growing privacy implications arising from modern digital technologies and extensive collection of personal information. The competition law and digital markets. This is another important topic of discussion at this summit, and it concerns competition within digital markets and concentration of digital power. Across the world, digital markets are increasingly characterized by concentration of digital power within a small number of multinational technology companies, controlling online advertising, app ecosystems, e-commerce platforms, cloud infrastructure, digital payment systems, social communication platforms, and access to digital services. This concentration of market power has generated increasing concerns regarding abuse of market dominance, anti-competitive conduct, exclusionary practices, exploitative digital practices, self-preferencing by dominant platforms, and unfair market conditions within digital economies. Uganda's Competition Act 2024 now provides an important framework for regulation of anti-competitive conduct and abuse of dominant market positions. Section 9 prohibits anti-competitive practices, while Section 11 prohibits abuse of dominant position within markets. Sections 12 and 13 further prohibit exploitation of consumers and exclusionary conduct by dominant entities. Similarly, Section 5 of the Uganda Communications Act empowers the Uganda Communications Commission to monitor, inspect, supervise, control, and regulate communication services and digital communication systems within Uganda. The Data Protection and Privacy Act equally intersects with competition regulation because dominant technology companies frequently rely upon extensive collection, monetization, aggregation, and processing of personal data in order to strengthen market power within digital ecosystems. Globally, regulators are increasingly responding to competition concerns within digital markets. In United States versus Google LLC, the United States Department of Justice challenged Google's dominance in digital search and advertising markets on grounds that the company unlawfully maintained monopoly power through anti-competitive agreements and exclusionary conduct. Similarly, in Google search shopping case, the European Commission held that Google abused its market dominance by granting illegal advantage to its own services within digital markets. The European Union subsequently adopted the Digital Markets Act and the Digital Services Act to strengthen accountability of digital gatekeepers and promote fairness and transparency within digital markets. Within Africa, Nigeria, Kenya, and South Africa continue strengthening digital governance, platform accountability, fintech regulation, and protection of digital rights within evolving digital economies. The era of artificial intelligence and the question of governance and emerging technologies. This is another important topic of discussion at this summit, and Uganda's emerging digital governance landscape is increasingly being shaped by developments in artificial intelligence, big data analytics, cloud computing, blockchain technologies, Internet of Things technologies, biometric technologies, and digital financial platforms. Artificial intelligence technologies continue influencing healthcare, education, agriculture, labor markets, public administration, scientific research, industrial innovation, and financial services. However, AI equally presents significant legal and regulatory concerns relating to misinformation, algorithmic discrimination, automated decision-making, cybersecurity threats, digital surveillance, ethical accountability, and protection of fundamental rights. Currently, Uganda does not have a comprehensive legal framework specifically regulating artificial intelligence technologies. This regulatory gap creates uncertainty regarding liability, accountability, ethical standards, transparency obligations, governance of AI-driven systems, and protection of personal data within automated decision-making environments. Proposed policy and legal frameworks around the world seek to establish safe and ethical deployment of AI technologies, protection of personal data, promotion of responsible innovation, and establishment of accountability mechanisms for AI-driven systems and automated decision-making technologies. This proposed approach is consistent with emerging international principles on AI governance. In recommendations on the ethics of artificial intelligence adopted by UNESCO in 2021, member states recognize that artificial intelligence technologies can significantly benefit humanity, but must be governed in a manner that promotes accountability, transparency, fairness, protection of human rights, and protection and prevention of harm. Similarly, the European Union Artificial Intelligence Act adopts a risk-based approach towards regulation of high-risk artificial intelligence systems capable of significantly affecting rights, safety, and public interests. So what is happening at the regional and continental level? At the continental level, the African Union cross-border data flow mechanisms, data categorizations, and data sharing frameworks are expected to strengthen regional digital governance through harmonized standards relating to cross-border data regulation, platform accountability, digital sovereignty, and oversight of multinational technology companies operating across jurisdictions. Likewise, the East African Community Regional Artificial Intelligence Strategy seeks to support harmonized regional approaches towards AI governance, strengthen oversight of emerging technologies and digital platforms, and promote responsible, transparent, and accountable use of artificial intelligence across the region. At the national level, Uganda is equally developing the National Artificial Intelligence and Emerging Technologies Strategy, aimed at strengthening digital governance, promoting innovation, improving public service delivery, and establishing policy and regulatory approaches for governance and ethical deployment of artificial intelligence systems. So what are the legal challenges and regulatory gaps? Some food for thought. So despite progress made in strengthening digital governance frameworks, several legal and policy challenges remain. First, enforcement against multinational technology companies remains difficult due to jurisdictional limitations and the cross-border nature of digital platforms. Secondly, regulatory institutions still face limitations relating to technical expertise, institutional capacity, and digital infrastructure necessary for effective enforcement. Thirdly, artificial intelligence technologies continue evolving faster than existing legal and regulatory systems. Fourthly, there remains inadequate public awareness concerning data protection rights, digital privacy, and cybersecurity obligations. Lastly, African states continue facing challenges relating to harmonization of digital governance standards, cross-border enforcement, and balancing regulation with innovation and investment. So what is the actionable policy and regulatory measures that we should be considering? I think there's a need to strengthen institutional and technical capacity for enforcement of data protection obligations and regulation of digital platforms. Governments should expedite development of comprehensive legal and ethical frameworks governing artificial intelligence and emerging technologies. Uganda should continue strengthening collaboration with regional and continental bodies in harmonizing digital governance standards relating to cross-border data flows, AI governance, and accountability of multinational technology companies. There's equally need to strengthen public awareness and digital literacy concerning privacy rights, cybersecurity, responsible use of artificial intelligence, and data governance obligations. Government should further promote collaboration between regulators, private sector actors, academia, civil society, and development partners in shaping responsive and innovation-friendly digital governance policies. So as I conclude, the Africa Big Tech Accountability Summit 2026 presents a significant opportunity for Uganda and other African states to contribute towards development of accountable, secure, fair, and innovation-driven digital governance systems. Whereas Uganda has made commendable progress through enactment of the Data Protection and Privacy Act and establishment of institutional regulatory mechanisms, the rapid evolution of digital technologies, artificial intelligence systems, and multinational technology platforms requires continuous legal reform and policy adaptation. Accordingly, Uganda's participation at this summit should emphasize the importance of balancing innovation, investment, privacy protection, digital sovereignty, accountability, and ethical governance in shaping Africa's digital future. I thank you for your attention, for God and my country. Aziz, I don't know whether this is the point at which I declare this summit open. If so, may this summit be opened, and I wish you fruitful deliberations. Thank you very much.
Join me to thank again our Solicitor General for such an elaborative and extensive discussion on data privacy, on the big tech accountability. This is the first of its kind in Africa. We are looking at these pertinent issues because we don't want to be left behind as the African continent. I'm going to leave with you some statistics to think about as we go for our bites. When you look at the Forbes richest men and women, majority of them on the list today majority of their wealth is being staked in AI companies, technology. But on that list, we don't have anyone from Africa whose wealth comes from AI and big tech. Meaning when they're in rooms, we are not in rooms where decisions are being made. But I want you to look at our population. Our population is growing so fast, but we are not in rooms where decisions are being made. We don't have sovereignty over our data in the actual sense. We have not had Africa as a continent. We have not had something substantial when it comes to enforcement. When these big tech companies do things that we don't agree with, many times we have failed at enforcement, but majority of our population, our data is being taken. We cannot guarantee security for our data. We can't guarantee enforcement where things may not go well. So that's why we are for this summit. We want to ask ourselves very pertinent question. What is happening to our data? Do we have data privacy? Do we have a say in what actually happens? Are we just consumers, or we can be actually able participants in the discussion of big tech? I thank you so much, our Solicitor General, especially when you mentioned on actionable policy, that we should come together and collaborate with the academia, with regulators, and with private actors. Because when all of us come together, academia for research, regulators to ensure that there is actionable laws and policies, and for private actors who may be engaged with these big tech, then we can have an overall review of how we can do better and be better. Thank you so much, Solicitor General. We thank you for your time. You have challenged us. You actually came very, very early. Thank you for keeping time, and thank you for coming. We appreciate you. We appreciate your views on this summit, and we shall forever be grateful for this opportunity that you've given us. We're going to go for the bites and breakfast as we wait for other panel members to come so that we can begin our panel discussions. Thank you.
Good morning and hello everyone. My name is Namgela Joel Peter. I'm a lawyer working with DPO Private Center East Africa. We are one of the strategic partners to the BTS Summit. I just want to tell you a little about the work we do at the Private Center. DPO is a professional services organization whose focus is on enhancing data privacy or data protection and privacy culture across East Africa. We are a team of young professionals cutting across the region with some from Uganda, Tanzania, Kenya, and South Sudan, where we focus mostly on doing research within this field. Many of us may be aware that this is a growing area of practice. So in many cases, there's little to no information or research on the various data protection and privacy issues. So we focus mainly on doing research, writing opinions and various publications on the various matters we think that are still open and unaddressed. And this information is either for academic purposes or practical use by the different practitioners in the various ways they may wish. Among the key publications we have is an annual publication, which is the East African Data Protection Guide, that brings together practitioners from 6 countries, these including Uganda, Kenya, Tanzania, Rwanda, Burundi, and South Sudan. They share the different perspectives on data protection and privacy, including key updates, regulatory developments, case law, and all these other things that, and we bring them in one pool for anyone that may want such a resource. Our first publication was released in April this year, and the similar second edition will be coming up next year around the same time. We also have monthly publications, which are newsletters. We highlight the different data protection updates across the region, the continent, and the world that we'll find relevant to people in the practice. We also issue various articles, like I earlier mentioned, that tackle the various aspects we think that are still untapped. We also offer trainings to data protection officers. These are on a need basis, but we also have a training that will be coming up next month, a beginner level training for early practitioners, data protection officers, students, among others. And if you follow our socials and our website, the publication will be put out soon, or the call for registration, and all details will be provided. We also provide data protection support in as far as compliance is concerned with the Data Protection Act here, and in the other countries we are operating, mostly Kenya and Rwanda. We assist organizations conduct data protection impact assessments, data protection due diligence for those that will have any kind of activities that may involve data sharing, to ascertain that where data will be shared, there are actually safeguards in place that safeguard this data. We also take part in similar discussions. We also organize discussions of this nature in as far as webinars and physical events as partners like we are here. Among those I could note of is a quarterly webinar that puts together East African practitioners from all the countries of our coverage and share on the different aspects of data. This quarter we'll be discussing about child online privacy, And once the call is out, we will invite you to join us. In the same regard, we have monthly discussions. These are localized here in Uganda, where we still speak about the different aspects that are relevant to building data protection and also creating awareness. We also take part in creating awareness in the data protection field. We provide trainings, free trainings, to different institutions, mostly schools. We understand the awareness levels are quite low. So rather than holding them to the non-compliance, we are taking an initiative to build the awareness through training these schools on how to handle data protection, moving to communities, among others. Yes. So you can follow us on LinkedIn, DPO Privacy Center East Africa, X, formerly Twitter, still under the same name, and our website at www.dpoprivacycenter.com. Thank you very much.
Good morning. I take this opportunity to welcome our distinguished guests. My name is Nicholas Morere, a member of AdLegal. Our audience that is attending physically and the one online, we thank you for your patience. At this juncture, our keynote speaker has arrived. Allow me to welcome Dr. Olumide Babalola. Dr. Olumide Babalola is a distinguished practitioner on the African continent. Recently, he was admitted on the English bar, and he also got his PhD. Dr. Babalola has handled some of the most pioneering cases on the African continent against WhatsApp and other big tech. He is our keynote speaker today. He secured Femi Lanini-san versus Meta Platform Inc., where the Lagos High Court ordered the company to pay 25K USD in damages for data privacy violations on platform of Facebook. He also led the landmark 2021 case of Digital Rights Lawyer Initiative versus National Identity Management Commission, a court of appeal decision that clarified the link between data protection and the constitutional right to privacy in Nigeria, now widely cited across Africa. He's a founder of the Data Privacy Lawyers Association of Nigeria, which was founded in 2024, chair of the Nigerian Bar Association Data Protection Committee in 2025. He's a co-founder of Digital Rights Lawyer Initiative. He also convenes PrivyCon Nigeria, a leading annual privacy conference in Lagos. It is our distinguished honor, ladies and gentlemen, to have him amidst us. And at this juncture, I invite him to give us his keynote address. Thank you so much.
Good morning, everyone, and may I start by appreciating the organizers for this invitation, the entire AdLegal team, and the ones who put together this event. Thank you for the invitation.
Because of time also, I wouldn't want to take too much of your time addressing you on what I've come to speak about. But first, I must appreciate what you're doing in Uganda, because I think you are one of the very few African countries who has really taken up the big tech in terms of accountability, in terms of showing responsibility. You know, up until 2025, I think, that we had no decisions or no either judicial decisions or administrative decisions or regulatory decisions on the big tech. When I dive into my paper, you would see why the status quo should not continue. I am particularly passionate about this. So when I speak, beyond what I have done or what the firm has been able to do or beyond what I have written on, it is something that also mostly affects most of us personally. So again, I'm honored to be addressing you all today. And I think occasions like this, gatherings like this, they will go a long way to shaping the future of privacy and data protection on the continent. And that's why we need to take them more seriously. So I have been told to speak on the topic, whose data, whose law, jurisdiction, extraterritoriality, and enforcement against big tech. I thought I was going to be able to share my slides. Can you project it? Can you? Okay, so if I share with you, you will be able to project it. Okay, so please, if you can help me take my phone there, and then I'll just send it to you, then you will just let me project it. So that everybody can actually follow. Thank you. So, okay, do you have iPhone? Do you have iPhone? Okay, yes, please send it. So while we're at it, you know that up until very recently, there were no court decisions that you could reference on responsibility of big tech. When I start sharing my slides, you would see that this big tech, virtually all of them, they do not have, thank you. I sent to you. Just check if you. Let me know when it arrives so that up until recently, even right now as we speak, most of them do not have bases in Africa. For many of them, you cannot communicate with them with any presence within your jurisdiction. You will most likely have to go to the United States, or for some of them, India. Let me know. Have you seen it? Okay, thank you. Some India. Recently, I even discovered the big tech does not have an email address for you to reach them. So you use their platforms, yes. You have concerns about the use. You have questions to ask. You have requests, legitimate requests to make, yet they do not have email addresses that you can contact them with. Beyond sometimes the necessity to use, or beyond lack of, thank you, so you could project that. Beyond our lack of understanding of the effect of using these platforms, we're mostly at their mercy. In this room, all of us are, thank you, So you can go to the next slide so that I can quickly speak to it then. Yes. So, thank you. So this speaks to the paradox that we have found ourselves in. And these things continue to confront us even in the court. I have had to answer questions around this in the courtroom recently, very recently. Now, whose data? In our context, the data is African. Everybody is on their gadgets, everybody is using their laptops, everybody is on social media, everybody is communicating. We're sharing our data whichever way, either with ourselves or with the entire world on social media. But in the process, we're also sharing with the big tech. The data, as far as the law of data protection is concerned, is hers, because these are information that directly or indirectly identify us. So the data belongs to Africa and Africans. But unfortunately, the servers where these data are processed or are stored, they are foreign. The data is African, the mechanism is foreign. For example, yeah, we will have to mention names. I mean, I don't shy away from that because, I mean, that's how we can even relate with all these things. Meta, for example, where is their server or where are their servers? If they are not in the US, they are in Ireland. Even if we don't know where they are, what we know is that the centers are not in Uganda. They are not in Africa. Then what law regulates these things? We continue to have contestations around the law that should regulate it. I will speak to that also very quickly. The data is for Africa. The server where the data, where they are stored, they are out of Africa. Then we are having conversations that the law that will regulate this relationship is also not African. There are also laws of countries outside of Africa. Now, what am I quickly going to talk about? Few concepts. The landscape, Uganda and other parts of Africa. The reality that we have found ourselves in. The case study. You know, you will not realize how much of some, for the want of better word, economic or social slavery that we have found ourselves until you have a problem with this big tech. You wouldn't understand how much we have either submitted ourselves to, or by design we have been captured one way or the other. Then the enforcement problem, I am still struggling with it. Then what's the way forward? So the amount of engagement that we make on using technology, it runs into billions. The mobile networks, the text messages, the tweets, the sharing of all sorts. So you can see the magnitude of what we are talking about. Then in Africa, we have 44 data protection laws. Depending on how you look at it, some might say they are even less, because some laws might not necessarily be titled the data protection law. In Nigeria, we've had a penalty of $220 million US, but maybe that's just for some aesthetics. We'll speak to it. Then in Africa, how many big tech data centers do we have? 0. To my knowledge, except you know, but my research has not shown me any. That tells us something. Now, jurisdiction, which is the problem litigation lawyers continue to have in courts. So there are 3 types of it. This prescriptive one, which is the power of the court to make rules that will bind certain conduct. That one, is not in doubt. The second one is the adjudicative jurisdiction, which is the power of the court to hear. The first is power to bind, it's not in doubt. The second is, even though the courts have powers to bind, for lawyers who go to court, a court might have powers to bind, but the court does not have jurisdiction to hear that case. Courts generally have powers under the Constitution, but some courts are created for particular cases. Do you have human rights courts in Uganda? What specialized courts do you have? Labor, election, petition, land. What did you call it? Commercial. Yes. So if you have a commercial court, then non-commercial cases cannot go there. Even though the commercial courts have powers to bind, but they don't have powers to hear all kinds of cases. I will speak to that as it concerns data protection and privacy. Then the other one will be enforcement jurisdiction. The courts can make decisions. The courts can grant orders. The courts can grant injunctions. But again, what about the enforcement? The court grants an injunction in Uganda. The court can only enforce in Uganda. For example, there's an injunction against me on anything in Uganda. Once I step out of Uganda, there's nothing you guys can do anymore. There's nothing the courts can do. So that's the enforcement jurisdiction we're going to speak to. And let me go back today a bit. Now, in terms of accountability for the big tech, this enforcement jurisdiction is about the biggest problem we have in the globe. And it is not just an African problem. Now, extraterritoriality is one of the most interesting provisions in data protection. And that's one thing that also interests me. And that's why we can be speaking about today's topic, because of the fact that the laws have made certain things extraterritorial. And it started from the GDPR. So when we saw the clause in the GDPR, some of us were just looking at it theoretically. If the law applies to entities that are not even in European Union, we were wondering, how are you going to go about it, or why would you have that? But that is something that has helped in the other parts of the world, because we have been able to copy it. What the clause simply says is that entities that are not even in a particular country, if they process data of people in that country, or if they target people in that country, then they are subject to the law of that country, which sometimes originally was not how the law usually operates. The law usually operates based on territory. So, but this one gives outside jurisdiction some bite. Now, of course, African states copied, and there's a problem with the way we copy in Africa, or even in Nigeria, where I come from. Most times when we copy blindly. Most times. We see something that we feel is good, then we copy it, hook, line, and sinker. And sometimes we don't consider our background. Sometimes we don't consider our society. Sometimes we don't consider our cultural reality. In the West, where I partly live, there's a way they interact, and there are things they share. And I find it, sometimes I cringe. But that is their culture. For example, a woman gets pregnant and she comes to the office and she tells everybody, I'm pregnant. In Nigeria, that is not our culture. You wouldn't tell someone you're pregnant until it begins to show. The person will see. Because of our culture. But for them, they don't have a problem with it. The other things they easily do, if they have some terminal illness, they easily tell themselves, oh, my supervisor actually sent an email. My second supervisor, when he was unable to supervise me for a while, sent an email that his son had brain tumor, and that's why he couldn't supervise me anymore. And I thought to myself, why did he have to say that? Because an African would not tell you that, or a Nigerian. they would just tell you, I am not available. But culturally, they don't see reasons they should hide that. And that's why you will see an African leader is sick. And nobody will know the source, the kind of ailment. The late Nigerian head of state was sick for a while and was traveling, and Nigerians don't know what was his problem. So we should understand that when we are copying and enacting law. Now, bringing this to data protection. Under the GDPR, there is what they call special categories of data, sensitive data. I don't know, I didn't check your Ugandan law if that is what you call it. In Nigeria, we call it sensitive data under the Nigerian Data Protection Act. Under the GDPR, there are special categories of data. And there are examples of this data will be health, will be philosophical beliefs, will be religious beliefs, will be criminal records. And also in Europe, it is sexual orientation. When Nigerians were going to copy, do you have anti-gay laws here? Yeah, so Nigeria has as well. When Nigeria was going to copy, Nigeria also copied everything, including sexual orientation. But I filled forms here. When I came in at the airport, I filled form. And I know what you guys only have in Uganda is male and female. In Europe, they have male, they have female, they have prefer not to say, they have LGBT, they have LGBT high, they have LGBTQ high, they have LGBTX. That's their culture. So you can't copy laws from that jurisdiction and then copy LGBTI, because you have laws that criminalizes LGBT. So when Nigeria was going to pass the law, I looked at the bill, I wrote an article on it, I wrote a critique that no, you cannot say LGBT, even though it is hypocritical in Nigeria. We say we don't like gay, but we celebrate them. So why? We are hypocritical. Because, some celebrities are gay, openly gay, and we celebrate them. So why are we going to have laws that criminalize something we celebrate? Shows we are not sure of what we want to do. Now, I wrote an article and I said, come, if you said you have criminal laws against LGBTI, then you cannot say it's a sensitive data, because you don't expect anybody to tell you he or she is gay because you criminalize it. So in Nigeria, they wanted to change it. They changed it. They removed sexual orientation. They added sex life, which even makes it more ridiculous. Now, I said that for us to see that we copied extraterritoriality from Europe, and it is a blessing, actually, because for us, where we don't have enforcement mechanism, it would have been more disastrous if we did not even have that. Now, if you look at some of the African laws, the one in Nigeria, the one in Kenya, the Ugandan law, and South African, we all have this extraterritorial jurisdiction. Now, looking at the Ugandan Data Protection and Privacy Act, your Section 2 talks about the reach. It goes outside of Uganda. Then you require some controllers to also register. Then you have cross-border rules. So you understand that when something goes out of Uganda, it is still subject to Uganda law under certain circumstances. Now, the gap that we found in these things will be, how do you enforce it? Especially Nigeria that has imposed fines. How do you enforce it against an entity that is not in Uganda? How will foreign courts recognize the orders that were made by your courts and by your regulator? Do we have anybody from the regulator here? Aziz? Did you invite them? They are not yet here, right? I thought it was only Nigerians that come to event late. I didn't know it was an African thing. Okay, anyway, they call it African time. So I was already agitated when 9 o'clock, he didn't tell me anything. When 9:30, I didn't hear anything. When 10, I'm like, okay, let's see. Now, so those are the gaps that we have. But this is not an Ugandan thing. It's a continental affair. Nigeria has extraterritorial, Kenya in their law, South Africa, and also the Malabo Convention, which you guys have not even ratified. Malabo Convention, I don't know why you have not ratified it, but even if you are not going to Nigeria as well, so I'm not just speaking about Uganda, we have not ratified it also. So, but there's a lot of benefits that we can all take from ratifying that law. So these platforms, what do? How do they make themselves out of reach? First of all, they don't have any local entities in your country. Do we have anyone? Does Meta have? Does Meta have an office here? TikTok? Google? So no big tech has their office. The same thing with Nigeria. But there's a twist to Nigeria. Now, so they insulate themselves from your reach by not having office in your country. Then, if you check their terms of use, we are actually litigating against Twitter in Nigeria, X. Their terms of use says if you have anything against them, you must go and litigate it in one European country. Arbitration, court matters, everything has to go to that European country. Of course, it makes it difficult for an average Nigerian to be able to take them up. Because, first of all, how do you even brief a lawyer there? Even if you are comfortable enough, if you are rich enough to be able to do that, that's a big problem for you, because you have to tell your Nigerian lawyer here, Nigerian lawyer will now brief a foreign lawyer. It becomes cumbersome. Secondly, if you have to give evidence, how do you do it? You travel there. It is very expensive and inconvenient. So they are strategic about it. So in their clauses, the terms of use, they put clauses there that make it impossible for you to take them to court in your country. And then their structure is so confusing. First of all, for you to understand their structure, you can go on Facebook and go and look for their privacy policy. Just look for privacy policy on Facebook. You will see they have many layers. There is the privacy policy for East Africa and Middle East. There is the one for Europe. There is the one for US. And even when you get to the part for Africa, they will still refer you somewhere. They might even first show you a video. They make it a lot cumbersome. So at a point, you will just leave it. And then that's the way their offices are as well. So they have the corporate headquarters, which could be in Silicon Valley or somewhere in California or somewhere in India or in Singapore. And they will now have regional offices. But in Africa, they are very mindful of not particularly having offices in Africa. Their corporate structure is that layered. Now, also choice of laws. In their terms, they will tell you it is only the law of America or the law of Ireland that is applicable. And you can see how ridiculous that is. You have, even on your platforms, you recognize Africa. Yet, if we have any problem, we cannot use African laws. We have to use European laws. It really doesn't make sense. Then, their infrastructure and their server, they are not in Africa. They are nowhere in Africa. So there is nowhere you want to say you want to get hold of where they store their data or how it is used. No, you cannot get it. Then the bargaining power, and I think this is the biggest one. The bargaining power, the asymmetry is so huge. First of all, these platforms are extremely rich. I heard that about 3 years ago, 4 years ago, one of the big platforms were having a meeting in Dubai, and the founder actually told the management that, I don't know, not confirmed, but that was what I heard, that they had certain fund that they were looking for ideas on how to spend the fund. And you would see the way they operate. They had, because you see kind of finds, you see the settlements they make in the US. Recently, Facebook made some billions settlements, they settled. I mean, especially when you have class actions. In those jurisdictions, they quickly settle class actions. But in Africa, we have not found our feet around class actions. I don't know how many class actions I've heard about in Africa. Do you guys do class actions in Uganda? I see, but I don't know how successful it is, or how much, or how quick it makes these corporations to settle with you. Now, the Nigerian situation. So, Meta was investigated in Nigeria for consumer rights violation and also for privacy violation. 2 entities investigated Meta: the Consumer Protection Commission and the Data Protection Commission. In 2 different investigations, they found Meta guilty. One was $220 million, the other was $38 million. Now, they did, at a point, they did joint investigation. But this is just to show you how perhaps Nigeria has led in that conversation, bringing them accountable. Nobody ever thought an African government or an African regulator could find the big techs to that amount, to that sum. But I think they did something commendable there. Now, when I heard about this Kenyan case, I also cringed, because it shows, even if you try to package Africa, the poverty in this continent will not allow that packaging to work. It is crazy that an entity will go to a country and ask people to be scanning their iris, their eyeballs, and they were giving them maybe $5 or $50 or something. And the queue was ridiculously long. They were even fighting. I mean, it shows the level of lack that we have on the continent. And you know, lack most times blinds you, because all you just want is food or shelter. In my PhD research, I studied the origin of privacy in Africa and Nigeria a bit. And I investigated why the African Charter does not have privacy. And my finding was, when the African Charter was being drafted, the biggest problem we had was not privacy. In fact, privacy was not our problem. What was privacy to somebody who was poor? Or what is privacy to somebody who is poor, who is looking for what to eat? They don't mind. They can give you anything. Just give them food. So I remember when we started this conversation also around data, and we spoke to some people, and the person said, come on, if they take my data, would they give me money? They said, yes, let them take it. What am I using it for? And that's the kind of reality we have found ourselves in Africa. Because data really doesn't make so much to someone who is lacking the basic amenities. And that's why the WorldCoin could do that in Kenya. Ask people to come, over 350,000 Kenyans enrolled. And many people were on the queue. So you can imagine how many people they would have gotten to enroll and submit their data for cryptocurrency or 7,000 Kenyan shillings. Then the government suspended it, and then. But the interesting thing about that is the order to delete the data that they had already gotten was supervised. Even though it was supervised. But nobody can beat their chest to say the entire data was deleted. So because if you delete it on one platform, do you know how many platforms on which they have replicated it? Let me tell you something that happened in Nigeria. There's an artist, a female artist, popular, called Tiwa Savage. Do you guys know her? So Tiwa Savage, some years back, had a sex tape. Somebody recorded while they were having sex and posted it on social media, and she was scandalized, and then she tried to get it off. And a year later, thereabout, she came online. I don't know what happened to her. I don't know what she was thinking. Then she came online to say IT professionals told her that that the sex tape does not exist anymore, that they had wiped it off. And if you know Nigeria very well, you know many Nigerians are jobless. So less than 10 minutes that she said that, somebody posted it online again. That you think so when you talk about digital footprint, you might not be able to completely erase it. So the Kenyan government said they supervise the deletion, but you never can tell how that thing had been stored, whether in duplicates, in triplicates, or in many places. So if you delete one, if you supervise the deletion of one, what about the others? What about the other places they have studied? So that is some of the dangers in even allowing privacy to be invaded at all. Privacy, you might not be able to do damage control when the damage has been done. Now for South Africa, they have an interesting definition of controller. They rather call it responsible party. In other laws, we call it data controller, we have data processor. The South African Act prefers to call it responsible party. And I think that emphasizes the responsibility on controllers. So much that when they infringe, there are notices, there are huge fines for them to pay, and they have conditions before they can transfer data abroad. All these things speak to the responsibility or the expectations of on a responsible party in South Africa. Now, what are my recommendations for how to be able to enforce this thing? Because it is a big problem. Against Google, we got judgment of $30,000. It is very small. It is, to them, from their perspective, extremely small. But we have not been able to enforce it. Against Twitter, I just got judgment. I just got 2 judgments against Twitter. Now, there are people who use Twitter anonymously. People use social media anonymously. In Twitter, I call that place angry place. Twitter in Nigeria is a very angry place. People on Twitter, angry people. And because it allows you to be anonymous. I mean, the anonymity on Twitter is bigger than all other platforms. So you see people set up several usernames, and they use it to attack people. There was one that they set up a parody account, and our client, they altered our client's tweets. In fact, she posted some pictures. They altered the pictures and made them sexually suggestive, like making her look almost naked and all sorts. But these are people you cannot identify. They were parody. So what were we going to do? So we took them to court. We took Twitter to court and took that unknown person to court. And we thought there has to be remedy. In law, where there is a breach or where there is a wrong, there has to be remedy. A wrong has been done. So we took them to court and we told Twitter, I mean, part of the reliefs we asked court was, yes, damages against that party and damages against Twitter. If Twitter does not, what we asked the person, Twitter, was for them to provide the details of that person so that we could enforce the court judgment. We were sure they would not easily want to do that, especially because you can't even enforce it against them. They are nowhere. We had to go serve them in California. Not every average Nigerian can do that. Serve them hard copy in California. Maybe when I go back to Nigeria, I will check whether they have complied with the court order. But that's how ridiculous it could be. So enforcement is the biggest headache. You can litigate. In Nigeria, it could take you, fundamental rights case, it could take a minimum of between 6 months and 3 years to finish it. So I'll go through that also, then I'll finish, I'll get judgment. I can't enforce it. Sometimes for me, the value I get in those judgments could just be development of our laws and jurisprudence. But beyond that, the victim wants to get compensated. Now, the suggestions that I am making, and also I am making to the Nigerian Parliament, because before the Nigerian Parliament now there's a law, or there's a bill that seeks to amend the Data Protection Act such that big techs can be compelled to have offices in Nigeria. If that law scales, it increases their responsibility and their accountability. But again, many people are fighting it, or organizations are fighting it because they are looking at it from different perspectives. And that's the interesting thing about privacy and data protection. Now, so the first recommendation would be to have local representatives in Nigeria, I mean, in your country. Even if you don't want to have offices, you should have local reps. People we can ask. For example, you need something to be rectified. There are many content, you guys, I know you have content creators, don't you? It's a big business now, big, huge. They are rich in Nigeria, very rich. Because of course, Nigeria has the number. If this event was in Nigeria, come on. Is it free? Did people pay? Is it paid? Oh, I see, okay. Even if it was paid, Nigeria, full. Now, because we have the number. Now, content creators in Nigeria, they can create content out of anything. Anything. Because we are so many, so there will be a whole lot of things for you to make content from. There was this guy who makes content, he makes comedy content by acting like an herbalist. You guys have herbalists too, don't you? I've never been to Uganda, so if I ask some questions, you should understand where I'm coming from. Yeah, but I mean, very cool place, nice. I mean, you can't get this kind of air in Lagos. The air in Lagos is polluted because of the number, yeah. So this guy acts comedy skits, and it was going viral. A young man that just left school, and he was making little change for himself. Then someone saw that the comedy was going viral, and the person replicated it. The person also created, so what the person did was to create another page. Then he would go to this content creator's page, lift his own content, put it on his own. Interestingly, the impostor had more followers than the real person. The real person had maybe about 20,000 followers. When he discovered the impostor, he had 5 million followers. And he was making money from it. He was making a whole lot of money. So we wanted to get this corrected. He wrote Meta, did everything. They did not correct it. Then, on his page, because I also watched some of his skits and I liked it. So I saw another page where he now complained. He was almost crying that somebody had stolen his page. So I thought, okay, let me help this young man. So I reached out and said, okay, you know what? This is what you can do. He did it. He reached out to them again. They didn't respond until they got my letter. And well, I think to some extent they know me. So when they got my letter, they rectified. Now, there are a whole lot of people going through that same situation because social media has become their means of livelihood. For a lot of people, we rely, oh, come on, even me talking, I wouldn't be here if not for LinkedIn. You wouldn't have been able to know about me. I mean, many people got to know about me because of LinkedIn, because I say what I do on LinkedIn and everything. So that's how much social media has helped all of us to amplify many things. But some people actually rely on social media for their businesses. for their livelihood. Then if other people steal their content, they are actually stealing their livelihood. How do we now reach out to these platforms to rectify this wrong? Now, what I was told in confidence by their lawyers is that sometimes even the emails they provide, even the platforms they provide, they are not able to monitor them because of the traffic. In Kenya, they used to have content moderators. They closed it down. Now they use AI for content moderation. It cannot be as effective. But if we have a local representative, if you have any problem with the big tech, you want anything rectified, you go to the local representative. Maybe not necessarily having an office. Because the argument they are going to make is they cannot have offices in all countries of the world. Yes. Or even if they cannot even have local, they can have regional. Like some person being responsible for some part of Africa, East Africa, North Africa. They have that war chest. So, and in one of the judgments we got against them, the court clearly identified that you are a big platform. The court can take judicial notice of what you are worth, your net worth. So these things are things you can do if you really want to do. Now, localization, data localization, it is staring us in the face. We need to get it done. If data is being processed in Uganda, then there should be laws that will say certain data should reside in Uganda. Data sovereignty, and also for accountability. When African governments begin to pass, Nigerian CBN just did that. But there's a problem around data localization, and that is the problem of reality. That's, do you have the infrastructure? But again, if you compare big techs to do it, they'll find a way around it. The fines, African governments need to wake up. There are certain fines you would issue, and then it will touch this big tech. They will take you seriously. I see what they are doing in Nigeria right now, even though some of the things I don't support, but I see they are taking responsibilities a top higher because of the kind of fines that have been awarded against them. So there should be huge fines that commensurate with their size. You can't look like at a company like Meta, then you are finding them $10,000. That's nothing. They would even rather pay the fine and continue. Then App Store. This is another creative way of enforcing judgment against them. I remember there was a particular time certain entities were precluded from having their apps on the App Store, on the Google Store, through the courts. That might force their hands to obey some of these judgments. Then, of course, regional coordination. It is ridiculous. And I said this thing about copy and paste. If you check the Malabo Constitution, the Malabo Convention, we have cross-border provisions there. But when I studied the origin and the reason for cross-border provisions, in Europe, they use it to foster European unity. Cross-border sees EU as one entity. Africans, we went to copy cross-border. And instead of seeing Africa as one entity, we are replicating separate cross-borders across the countries. So if data is coming from Nigeria to their neighbor in Ghana, we see that as cross-border. Ordinarily, if we want Africa to grow, we can't continue to see those cross-border provisions the way they are. There shouldn't be cross-border that limits a country from sharing data with their neighbor. There should be safeguards, but that limitation should be lifted. So there should be regional corporations on how to enforce this judgment regionally. Then judgment recognition. There should be improved recognition of judgments gotten from African countries in other parts of the world where these big techs are. Now, as a roundup, so just like I said, you can win judgment. You can get judgment, and at the same time, you're losing the remedy. You are unable to get the remedy. So the judgment is just Pyrrhic, it's just on paper. One of the problems we keep having is that of service. How do you serve a big tech that is not in your country? In some cases, we have succeeded. In some cases, we did not. In fact, in some cases, some judges said we cannot serve them by email, ridiculously. They said, no, you can't use email. The judges would prefer us to go and serve them in California. That's a lot of money. From a Nigerian perspective, it's over $100 to serve them abroad. And if you know the minimum wage in Nigeria, it is ridiculous. So how does an African do that? Now, when you get the judgment, there are no local assets to attach. If you want to enforce the judgment, how do you do it if they don't have assets within the jurisdiction? You're just there. Then there is also this problem of non-recognition of foreign judgments. I understand there are some states in the US that don't recognize some judgments from Africa because there are no treaties or there are no bilateral agreements between the countries for that. Regulator. Where is your regulator based? Is it in Kampala or Entebbe? Yeah, and I can imagine how many employees they have. Do they have up to 200? Never. 100? Even Nigeria, they struggle. I don't even think Nigeria has up to 50. If they do, and let's even say they have 100, they are serving 200 million people. And they said they have well over 500,000 companies to look. So it is ridiculous when you do the math. So the data protection organizations do not have this capacity. So, and if they don't have the capacity, there's no way they can really enforce these things. I remember when I got judgment, they reached out to me from the data protection office and they said, before I file suits, that I should try to work with them so that they could also maybe even solve these problems. So I said, no problem. Even as I speak, I have some cases I want you to handle. I'm talking about 2 years ago. I wrote a petition and sent it to them. Up till today, they've not decided it. 2 years ago. They have not even called us. So I understand their capacity. And I told them, I said, it's not as if I don't believe. I work for you. There are many things I've done. I have taken the government to court because of funding for them. So they know I'm their biggest cheerleader. But again, I will call you to question when I see you are dropping the ball. I know you don't have the capacity. So if you ask me to send petition, and I send petition and it takes 2 years, I can't spend 2 years in court. The same time I sent them the petition, I went to court. I got judgment for that case in less than 8 months or less. And they are still on the petition. So yes, they have capacity problem, and it cuts across Africa. Because funding issues, because of expertise issues, because of professional issues as well. So these are part of the problems we have. Then regional cooperation, we really don't have that. So when Adliga reached out to me and told me about this event, I was excited to come because I believe this is what will really help our continent. I mean, fostering this regional cooperation, this regional sharing of ideas, and seeing how we can improve our lots. Because in Nigerian courts, I've had to use cases from Kenya, I've had to use cases from South Africa to persuade the Nigerian court to take certain decisions. It took me 3 years for me to persuade the Nigerian court to recognize false light as a privacy interest. The court would just see it as defamation, as libel. We kept on doing it. We failed until we started citing some foreign decisions that they should see the way even fellow Africans look at this thing. Everything is not libel. Because when you study the origin of privacy, and that's part of the things, I mean, that's what my PhD thesis is on. Privacy started when people realized that libel cannot solve all problems. In the 18th century, 17th century, all they had was libel. But some celebrity wanted to do wedding, and they didn't want paparazzis to come. They didn't want people to come and take pictures. If people had come to take pictures without their consent, it wouldn't be libel. And that was when they advocated for privacy. Until I had to do that kind of lecture in one case, before the court now looked at it and reasoned that, okay. But part of the things that also helped was because South Africa had delivered a judgment like that, and I think I found something like that in Kenya too. So we can easily relate what other Africans have done and how best Africans can do these things. I tell you, before 2024 or 2025, the big techs were not really taking Africans seriously. They were not. They really, that's my judgment that is giving them a whole lot of headache. They reached out to us for settlement. Not a problem. We wanted to settle because the applicant is a senior lawyer, and he asked me, and I said, sir, whatever you want. But you know me, I am just after developing this area of law. So if you really want it, let's take it. And the man agreed. But they went back and they told me, some of these things, I just sit down in my closet and they come and tell me. They went back and they discussed that because this is an African country, and if you know how much they were offering, this is an African country, and if they did that, I found it very ridiculous and demeaning. And they said they were not going to settle. We went ahead. The rest is history. And that is what has emboldened other courts and other applicants to also be able to take them. After my case, I hear about a lot of other people are taking them to court. I mean, first of all, people didn't have that courage because they thought, oh, these people are unreachable. But now, so when you see other African countries, that's why this cooperation is very, very important to development of this space. If Africans didn't care about privacy before, I think now with our dependence on technology, you won't know how much you are dependent on technology or on your phone until you don't have internet on your phone for maybe like for 1 hour. The trip I made from the airport to this place was the longest I have done in a long while because I didn't have internet on my phone. I felt like I was in prison. But that's how much we have been addicted or subjected to these platforms. So we cannot afford to take privacy the way we used to take it in the past. And when you begin to see that all of us will begin to have personal experiences around privacy, that's a personal experience I always share, data protection. So the first time I wanted to travel to the UK was in 2013, and they didn't give me visa for reasons obvious to them. They said I didn't look like I would come back to Nigeria. I looked like I would run away. I stopped applying until I had an invitation to speak in the UK in 2017, I think. Then I applied and they gave me visa. So my first visit to the UK was 2017, and it was, and I got to the port of entry, submitted my papers and everything. So they said no, I couldn't go in. They asked me to sit down. They gave me a deportation notice. They said they were deporting me back to Nigeria. I was wondering, what did I do? They went inside, checked. After like 10 minutes, they told me to go, that I could go in. I did that. I traveled, I think, June 2017. Then I had something else to do in July or August. I went again. The same routine. They asked me to sit down, gave me deportation notice. After like 10 minutes, they went to check my record, and they asked me to go. So between 2017 and 2020, I went to the UK more than 10 or 15 times. The same thing happened to me. So at the port of entry, they asked me to sit, give me deportation notice, then come back. So 2021, I became a resident of the UK, and it continued. They would still ask me to sit down, such that I began used to that routine. So once I got to the port of entry, before they asked me to sit down, I'll go and sit. I'll be waiting for them to. But it became embarrassing because I was a resident there, and there was one trip that made me very, very embarrassed. I was traveling from Lagos, and on that plane, the moment we left Lagos to London, the moment we left, from that moment till we got to London, people were fighting on the plane. I don't know. Fighting. So it was already a tense journey. So I got down, and I was part of the people that left the plane first. So I got down, and I got to the port of entry. They asked me to go and sit down. So as I sat, my countrymen who were coming from Lagos, who were angry with themselves, when they saw me that I had been detained, they were laughing.
People were angry. They used me as comic relief. And they said, oh, yeah, this one is going back to Nigeria. I felt very embarrassed because I was a resident. So I went to them and I told them, when they told me to go in, I said, no, this is already becoming embarrassing. First of all, I am a resident here. Secondly, I've gone to many countries. I never jumped visa. So why would you be doing this to me? And the guy told me point blank that from what I can see on your record, this will continue. I said, oops. Then I said, why? He said, the refusal of 2014 still shows on my record. And that's why every time I get to the point of entry, they would ask me to sit down because they have to go check my record. And data protection, you have a right to rectification. And there's a principle of accuracy that whatever data you keep of anyone has to be accurate and up to date. So I went to my house, wrote a letter to the Home Office. First of all, introduced myself, what I do, and cited GDPR, and also cited UK GDPR. If you have this in your laws, and also the Immigration Act says they can only keep certain data for 5 years. So I cited all those things, told them, it's already getting embarrassing, you can't be doing this. In less than a week, the Home Office responded, and they wrote me, they apologized, that truly they should have removed it from my record. And since that time, they removed it. I mean, my going into the UK is even more seamless than going to Nigeria. From that moment, and just because I activated that. So privacy is not just it's not just theoretical. And I've had many personal experiences with when you will have to activate certain things in the data protection law or the framework of any country you're going to. So as Africans, we are even the ones who bear the brunt the most. Because first of all, enforcement is a problem. Secondly, inherently as Africans, we don't really value privacy so much. We don't. Maybe we have started now, but before it wasn't, but now that technology is all over the place, we need to see it differently. And as professionals, our work is cut out big time. Now, I will have to speed this up, even though you did not tell me how much time I have. But this is what I do for a living, so I can talk from now to yeah. So yes, so if you look at their terms, is there anybody in this room, even if you say you are, well, I can believe you, is there anybody here who reads terms and conditions before signing on any platform? You will take your time and read clause by clause by clause. I doubt if there's anything, because these terms are very long and they're tiny. And anyways, sometimes we don't have a choice. We just want to use the platform. So you are not even reading anything. Whatever they write there, I accept. So most of the terms, they stated there that you cannot sue them in your country. They stated there that the choice of law is the law of another country. But because we want to use their platform, we don't have alternatives. And that's why China is doing something fantastic. China has alternative to WhatsApp. I think that's QQ or something. In some countries in the East, you can't even use WhatsApp. They have theirs. Africans, one way or the other, we also need to begin to build these platforms that can work for us. Our own platform, whichever way it is, we just need to begin to build it. And trust me, it's just a matter of time. Now, so from this contract, we somehow enslave ourselves because we agree. But there's a twist to it. We're in court with one of them. They came to court and they said, yes, the applicant agreed. The applicant signed. The applicant accepted. But the first question I asked them, which they were not able to answer, if you say the applicant signed, where's the evidence? And definitely that case will make them change their style. Because the Falanos case made them change their approach to consent. The week that we got judgment, they sent me something around consent. So, because if you say, I just click, yes, I know there's what they call click wraps. But if you say, oh, I accepted, you need to show the court how I accepted. You can't just show the court the terms without showing how I accepted it, when I accepted it. And there are many things they will need to do that. They didn't bring that to court, but yet to see how the court will decide that. Then the other thing, they put it in those contracts that they can change the terms at any time. It is there, we agree. But the problem of that, which they will also struggle with in the future. In fact, there's a recent Nigerian Court of Appeal decision on that with regards to telecoms. That if you are changing terms and conditions, you need to show the court that you brought the new conditions to the notice. And you need to even show the users what exactly you have changed. I cannot accept what I did not know. And that takes us to consent. I don't know in your law if you have also the implied consent. Nigeria, they have introduced it through the back door, but it has started giving them problems. Because if you say something is implied consent, there is no way you can achieve all the elements of consent. In data protection, consent has to be voluntary. It has to be specific. It has to be informed. And the purpose has to be stated. And then the person must communicate acceptance. Now in Nigerian law, in one of the directives, they put it there that when somebody comes to an event like this, and they take pictures and they do videos, that you have given implied consent for them to use the pictures and the videos. On the face of it, you will say, oh, true, because you came and you saw video and consent. But that's not true with the way the law of consent works. For example, the law says it has to be voluntary. Except you are telling me that as I have come all the way from Nigeria to come and speak to you, I have voluntarily agreed that you are going to do video and take my pictures. Yes. Let's even assume here you told me. Yes. The second question is, if I agreed that you were going to take the video and take the photographs, what did I agree you are going to use it for? You have to also show. That's number two. What you will use it for. Let's even assume what you want to use it for is publication of your event. And number three, you would also have to show that I agreed to how you are going to use it. Which makes consent very, very problematic. Because let me tell you why the how is a problem. With the kind of cases I do, I don't suck up to all platforms. In fact, there are some platforms when they hear my name. That's why I was discussing with him. That if some platforms hear that I'm speaking at an event, they will not sponsor the event. Yeah, it happened in Lagos. There were some people who called me to come and train them. Even though the time was not convenient, I was meant to be somewhere in Europe. But I said, okay, I was going to... that's the way I work, actually. If I am passionate about something, and if it's data protection, I try to make way for it. I'm supposed to be in the UK right now, but I mean, part of it. So, now they heard about the event, and they said because I was speaking, they will sponsor it. So I told them, so that you don't lose the money you're supposed to get, I will decline the invitation. So, if you tell me that I gave consent to taking my pictures, you cannot possibly tell me that I gave consent to using my pictures on all platforms. Or that I gave my consent to the way you are going to store my picture or who you share it with. So that consent cannot be specific. And that's where consent is problematic. But we have copied it. But we need to begin to also interrogate these things. Because what works for them might not necessarily work for us. Now, the counter argument that we always make with that is that, privacy is a fundamental right. You cannot use contract to derogate. Then also the consumer protection doctrine protects consumers from these unfair terms, because these are unfair contract terms. Then of course, in the data protection laws, there are extra territorial provisions. So those ones would also protect or allow you. Now, what are the lessons that we have learned from other regulatory powers? European Union, I said it, they have their own. United States, they have their Cloud Act, which compels all those US-based providers, wherever they are, they can provide data So even they are in the US, but the data is not in the US, they can provide data from wherever it is. And also China is a fantastic example. Because of the way we are now with data, we will know that our approach needs to be different. Now, I have said this earlier, we need to find a way around continental leverage. Working as a team might help us to build the kind of ecosystem that we want to build. Malabo, we can put pressure. Coincidentally, when Nigeria did not pass the Data Protection Act, I went to court. I took the federal government to court that if they are not going to pass the act, then in the country we should be able to use the ECOWAS Convention on data protection. When they saw that, after a while, they sped up the passage of the act. So sometimes your reliance on regional or international treaties might also help whatever narrative we want to drive. Now, the Europe has this their one-stop shop where you can get almost everything from cross-border to investigation to... If Africa has a data protection convention, then from the African perspective, we should be able to have an office that is responsible for that. In Nigeria, what also worked for the Meta case was the joint investigation. The consumer body and the data protection body worked together and they were able to make the necessary impact. Now, what recommendations would I have for Uganda as I close? Yes, you might not be able to amend, because sometimes it is not that easy to amend laws. You might not be able to get the legislature to amend it, but maybe your regulator can issue certain guidelines. Kenya is doing very well with the issuance of guidelines, or what they call guidance note, which helps to be able to, so it will specifically provide for all these things. The liability, platform liability is also a big problem. In fact, it's one of the arguments in that Falana case. Platform liability. Then the capacity is something you need to begin to work on. So even if the regulator, so what we have been able to do is somehow we have been able to use the courts to help the regulator. There's a judgment that the Nigerian regulator is celebrating just this week. They have got to town. They are really, really happy about that case. I filed the case. I filed the case for them. So I even told them after, see, you people don't like the court. Look at this judgment now. It's about the biggest confirmation of your powers to register, what do you call it? Thank you. Yeah. So then the regional, I've spoken so much about the regional leadership that we need to provide. Multi-agency coordination, you really can't wish that away. And I see that data protection in Africa, they're having all sorts of meetings and conferences. Most importantly, the Law Society has a lot of work to do. A lot of work to do. What we have found in Africa is there are not so many professionals. Even so many people posture as doing data protection, but we should have much more than we have. And that's when we will not easily. So one thing I found as I close, one thing I found about the Falana case, when I read comments on social media, I find them very amusing and also very instructive. I also learn from them. But the problem with that is many of the people making comment, most of them, they are in other jurisdictions apart from Africa. So their perspective has always been based on what they see from that other jurisdiction. What I'm going to leave you with, in Europe, privacy and data protection are separate. In Europe, there is Article 8, and I think there is Article 7 or Article 9 in their convention. Recognizes privacy separately, recognizes data protection separately. In Nigeria, for example, we don't have that. The only way you can ensure that data protection is also recognized as a fundamental right is for you to fuse them. And that was the approach I used. Right? I knew what I wanted to achieve, and we ran with it. Oh, sometimes you will fail. Many times we fail. Oh, many times. I filed over, I'm trying to count the number of cases I have filed in data protection, and many of them I lost. But the ones I won, they are the ones shaping the industry. And they are the ones that the courts are referencing. So we will understand what works for us. And we will be able to champion the cause of what we can relate with. Once again, thank you very much for the invitation. I'm honored to be here. Thank you.
It's a privilege to hear from you, Doctor. Thank you so much. One of the greatest on the continent in the areas of data privacy and data rights. Thank you so much. Because we are time bad, I'm going to invite the next panel. We are going to have a panel discussion, and I'll call upon the panel members who are already here to come. I'll start with the moderator, Anita Ntale, partner, Alba Advocates.
Thank you, Adlego. Thank you, organizers. I'd like to add my voice to the organizers to thank the keynote speaker for such an insightful engagement. We are privileged to have had you share your vast knowledge with us. Without further ado, I'm Anita Nantale Kalema, partner Alba Advocates, and I'll be moderating this very good panel. And I would like to call them up one by one as they take their seats from my extreme left. Yeah, and being a lady, I'm biased, of course. I'll start with the lady. So the speaker, the panelist coming up, is a very driven and legal personnel in governance. She has a strong track record in corporate advisory, regulatory compliance, institutional leadership with over 8 years of experience, and in-house counsel. And also, she has demonstrated exceptional competence in risk management. As a legal manager at National Water and Storage Corporation, she leads the legal advisory section for the Kampala water area, advising the corporation on contracts, statutory interpretation, ADR, employment law, and she has also championed key institutional reforms, including the digitalization of property management systems and the establishment of legal aid clinics. Beyond her corporate role, she has demonstrated strong governance and board capacity. She made history as the youngest board member appointed to the Uganda Law Society Elections Committee and serves on the in-house lawyers committee of the East Africa Law Society, contributing to regional professional development and institutional accountability. Ladies and gentlemen, her profile is quite long, but I will note this. She is equally passionate about enterprise and social impact. She's a venture capitalist with interest in hospitality and tourism, and a founder of the Kitabu Book Project, a non-profit organization across Uganda. Her leadership and professional excellence have earned her multiple recognition, including first runner-up in the in-house Legal Trailblazer category in the 2026 Legal Innovation and Impact Awards. I could go on and on, but ladies and gentlemen, let's put our hands together for Brownie Ebal as she takes her seat. And let's get ready for the next panelist. So, thank you, Ebal, for joining us. The next speaker or panelist has a very big, very big profile. I will try to be as brief. He, for gender balance sake, he's a founding partner at Chirunda and Company Advocates, one of Uganda's leading commercial law firms. He is a distinguished corporate and commercial lawyer, an academic and technology law expert with extensive experience in banking, finance, international trade, AI governance, data protection, fintech, and dispute resolution. He's a lecturer at Makerere University, has served on Uganda's 4th Industrial Revolution Task Force, and has advised both public and private sector institutions on emerging technology and regulatory frameworks. He is also a published author, a member of the Permanent Court of Arbitration, and a respected thought leader on the intersection of law, technology, corporate governance. Please join me welcome Counsel Robert Chirunda, as he takes his seat next to Brownie. So the next speaker, for gender balance sake, like I mentioned, we're gonna have a lady all the way from Kenya joining us today for the Big Tech Summit. We have a lady who is an international development strategist from and based in Kenya, with over 8 years of experience working at the intersection of strategic partnerships, research, policy, and advocacy across Africa, Asia, Europe, and Latin America. Her work spans regional health systems, digital rights and inclusion, tech and AI governance, gender equality, and youth-led development. She brings a strong commitment to community-driven approaches and people-first principles to her engagement with regional and global development frameworks. This is none other than Miss Lilian Njeri Mbuthi. I hope I pronounced that well. Let's give her a big welcome. And lastly, the gentleman joining us shortly is a partner at CR Amanya Advocates and Solicitors. His practice spans construction management and litigation, insurance, commercial litigation, insolvency, land and arbitration. He has been lead counsel in high-value commercial construction and insurance matters, both in courts and arbitral tribunals. He has successfully handled high quantum disputes, including a USD 10 million recovery and license rights for an international mining company. He has successfully handled multi-million arbitration cases, and he's a leading condominium developer in Uganda. Ladies and gentlemen, joining us right now is Counsel Harold Turije from CR Amanya. Welcome. Okay. Ladies and gentlemen, thank you for joining our conversation. Sorry. As the very first panel, I would like to set the pace for the day by welcoming you to the Africa Big Tech Accountability Summit. It is my great pleasure to welcome you all to this special summit session, focusing on boardroom accountability in the age of AI, corporate governance, responsibility for AI adoption in African businesses. That's what this panel will be all about. And as we know, artificial intelligence is no longer a technology of the future. It is already influencing how we make decisions, how we deliver services, how we recruit talent, how we manage risk, detect fraud, interact with customers, and even shape public policy. Across Africa, businesses are embracing AI at an unprecedented pace. But as innovation accelerates, one important question remains: who is ultimately accountable when AI makes decisions that affect people, businesses, and society? Yeah, that responsibility does not rest with technology alone. It rests squarely with boards of directors, executives, legal advisors, regulators, and governance professionals who must ensure that AI is adopted responsibly. So today's discussion therefore comes at a critical moment. We will explore what the effective board oversight of AI should look like, how organizations can balance innovation with accountability, and what practical governance frameworks African businesses need to build while remaining competitive in digital economy. So we shall dive right in. I cannot wait for you to hear from the very experienced and very ready panelists. And I cannot wait for them to deliver their speeches to us. Starting from the lady that took the very first seat with us. Councillor Ebal, first greet the audience, then I'll get back to you.
Thank you so much, Anita. I'm very happy to be here, and I'm privileged to be on this panel with such distinguished members of the bar. Thank you.
Thank you. So over to you, Brownie. As a corporate governance expert and AI, traditionally, they say boards oversee financial, legal, and operational risks. How should AI become part of enterprise risk governance? I think we shall start from there to kickstart the conversation.
So in regards to corporate governance, that is how organizations are structured, looking at their board, the shareholders, the management, and how do we hold corporations accountable. AI should not only just be looked as a side project or something you grab onto because it is trending. It should be something that boards should look into because it affects every part of our businesses right now. According to the McKinsey report of 2025, it states that, 2024, it states that 65% of organizations are regularly using generative AI in at least one business function. So if you're a business owner, you should know that whether you agree to AI or do not, your employees are going to be using AI to generate some of the work that they do. So it is imperative that we look at ensuring that AI is part of an enterprise risk governance. It should be integrated into the full risk committee, because normally on boards, we have the audit committee, we have the risk committee, we have the remuneration committee, and it should be added in the AI risk, in the risk register. So normally when they're reporting to the board, the committees look at the risks in the organization, and there is a risk register. That register should put in a slot for AI so that it is something that is well-rounded in the governance of the committee. An AI policy also should be used because should be integrated and established early because if there is no policy, then anything goes. Right now, for example, in South Africa, there was an AI committee that was set up. I was recently at the Legal Innovation Summit, and unfortunately, the AI policy that was drafted by the National AI Committee was taken down because they used AI that had hallucinations. So imagine the committee that is supposed to be overseeing the use of the AI also is not sure of what is happening. So that gives you the kind of lack of knowledge, the kind of new spaces that we are going into, and the risks that are involved, that if you're not very careful, anything would go. So if you have an AI policy in your organization, you can be able to control that and manage that. The initial draft national AI policy for Uganda is not yet out, but hopefully it will not be withdrawn like the one for for South Africa. So AI should become part of enterprise risk governance through integrating in the risk committee, have a slot in the register, and having an AI policy. Thank you.
Thank you, Brownie, for stressing that AI is part of life and should be fully integrated into the day-to-day running of business. Over to you, Councillor Roberts. We would like to know, AI increasingly intersects with data protection, intellectual property, competition law, and consumer protection. How should boards ensure compliance across these overlapping legal areas?
So first of all, let me start by thanking the organizers of this amazing summit. It is important to recognize just how critical the intersection that they've created is to everything we do. Those of us who are in private practice, every single large transaction now, we used to have an advisor on one transaction who can figure it all out. Now, the question you've asked me requires at least 3 or 4 experts, each of them having to comply with a different set of requirements, which are all intersecting and becoming necessary in not just knowing the technical detail, but also figuring out how these pieces talk to each other. So I just want to say thank you very much for putting this together, and also thank you for having me. It's a privilege. To come to the question you've asked, my goodness, it's too loaded. So I will take it from where Brownie has left it. When we started talking about AI maybe 3 or 4 years ago, it was okay to say, it was easy, even a year ago, it was easy to say write an AI policy. Yeah. Now, that question is a lot more complicated. If we start with the most recent, one of the most recent events, the problem with these things is, in AI there's an event every 6 hours. So you have to pick which one to talk about. But let's pick one that happened last week when OpenAI came out and said, oh, by the way, one of our confidential models escaped. I'm translating to English. You know, the Nigerian, they say, they have their own English. Even us in Uganda, we have our own, where we use phrases that are uniquely Ugandan. Let's think about that incident for a minute and use it. I'm going to try and use that as a linchpin to make my comments, right? Just one incident. One of the biggest AI labs in the world today says, listen, we have this thing that the world doesn't know about. And by the way, it escaped and attacked some other player whom many of us did not even know about. And as a result, it did things it should not have done. Right? Now, you have to imagine that scenario from different spaces. So, one, what really made OpenAI publicly acknowledge the mistake? It wasn't because they are angels in shining armor. No. But 2, you have to ask yourself, the other guy who got hacked by a tool, okay, what are his options? Then you have to ask yourself, the customers on both sides. And then you have to ask yourself, if they're telling us what really happened, they're not telling us the fullest extent. So how bad was this? The way I see it is that we have to think about this thing from a multi-dimensional perspective. In one context, I have suggested a 3-pronged approach. The first is to go from audits to continuous control as a board of a company, right? Now, it depends on which company you're talking about. If you're the board of the AI lab, I met one of the people who used to work with us at our firm yesterday, and she said, oh, I'm building a legal AI tool. And I said, oh, good for you. Let us know how it goes. So my answers to you as a developer would be different from my answers to you as a consumer. My answers to you as a consumer will be different from my answers to you as the AI lab. My answers to you as an AI lab will be different from the answers I would give a regulator. So let's just take one of those. You're a consumer. You go and you procure. I think earlier in the year we saw an announcement that one of the biggest law firms in London, since we are at a law event, one of the biggest law firms in London, Magic Circle firm, Freshfields, did a deal with Anthropic and said, you know what, let Anthropic help us to build. Now Anthropic, Google, all these labs have said, basically they're not writing code anymore. AI tools are writing, the AI agents are writing code. We've gone to autonomous, to agents. Now, the question you have to ask yourself if you're on the board audit committee, which meets every quarter, and they bring you a paper, is that paper still current? In a field where things are changing every 6 hours. Okay, maybe 6 hours I'm being hyperbolic. At least every 1 month, there's a new event, there's a new development. We saw what happened not too long ago with Anthropic and their latest model, Fable. They released Fable, and in less than 24 hours, the US government says, shut it down. Reason? National security. Every time a government screams national security, they have more to worry about than they will ever tell you. Now, it could be that it's China versus US. You're growing too fast, this thing is too big. Yeah. But I return to one of the things I said in the beginning. I genuinely believe that everything these companies are telling us is what they can afford to tell us now. What they are actually doing is far more complex, far much worse. So, when we talk about, when I say let's move from audit to continuous control, we must have frameworks in our organizations that are checking the risk register on a continuous and daily basis. Now, that becomes even more complex when you are told the agents, basically we have achieved singularity. I first heard the term singularity in 2017. And this is what was amazing. I was at a conference at a law firm in London, and the speaker, fantastic guy, ended with a question. He said, I would like you to make a prediction. This is what singularity is. When do you think it will occur? Most of us said 2050, I think the closest person said 2040. He put up a slide and it had only one thing on it. It had the year, 2017, and he said 2027. We all thought this guy is clearly a dreamer. By now you've seen Dario Amodei's video saying we're reaching the end of the curve. Basically what they are trying to tell us is, guys, in that framework, the only thing I can only think about 3 things that can help to solve this issue. Continuous control, moving from audit. The second suggestion I would make is supply chain safety architecture. When you are procuring, you are MTN, you are buying, it doesn't make sense now to buy, to build the tool from scratch. The compute is too much, the time you need, people have built whatever you want to build. It's like when we were on the rise of apps, everything was an app. I saw a video 2 nights ago about this Nigerian lady who has built an AI tool for braiding hair. And I thought to myself, now we are taking it too far. These Nigerians, we must arrest them. But I want you to think about this for a minute. Ladies, when they are thinking about, the ones I have spoken to who are gracious enough to have a discussion with me about braiding hair, will be in 2 categories. Either they are dreading the pain, or they are dreading the time it takes to braid. But for some reason, none of them ever cancels the appointment. Now, I think for the first time in my life, that video got me thinking about the hidden value of a braiding session. The gossip. You see, we call it gossip and we make it look untidy, but think of it as intelligence. The amount of information you collect sitting in that saloon, because you really have nowhere to go. Before social media, you had no choice but to listen to what these women are talking about. And believe it or not, just because you never reflected on it, you actually left wiser. So if you think about it as an intelligence session, as a TED Talk, all the West does is package these things differently. But really, Facebook is a gossip platform. If you think about it, at its core, X is a platform where we go to abuse each other. That's what village gossips used to do. Because they were stay-home wives who had nothing better to do with their time. Now, just because we do it on a fancy, expensive gadget, doesn't change the nature. People engage with you and insult you for things they have no clue about. How different is that from a market vendor arguing by the roadside? What has happened, therefore, is a disruption of that space. But you see, if you think about, let's assume I am right that a grading session is an intelligence gathering session. What happens if I build an AI tool that listens, translates, and then learns our society based on those conversations? You want to talk about accountability? Let's talk about how you hold the builder of that tool accountable. Because they are rewriting society. Right? So we have to think about, if you're talking about building that tool, there's a supply chain element there in terms of how are you sourcing which models you're building on. I advise my clients and say, if you're going to build, first think about the culture of the lab you're using. The culture at OpenAI is very different from the culture at Anthropic. Anthropic is more moral and more conscious. They're worried about the world is going to be in trouble. OpenAI, when they're fighting with the US government and the US government is saying, we can use a tool for whatever we want, the other guy is saying, by the way, you can't use my tool for that. This guy is saying, we don't control what our clients use our tools for. When you're making a procurement decision, remember that the culture of the people whose tools you're buying will affect what your tools do. It will affect how you regulate what data you're using. It will affect who uses which data, how. I tweeted this and someone on Twitter said it's a lie. And I said, I'm happy to show you the conversation. I was working on submissions one night. And I used a particular tool, I will not say which one, to refine my arguments. And it asked me, would you like me to do this the way a lawyer at this law firm or this law firm does it? And it mentioned 2 of Uganda's law firms. It's 2 a.m. in the night. It's been a long day. This catches your attention. So I casually asked, tell me what the guys at this firm actually use you for. Believe me, you don't want to read what followed after. But he just told me that somebody in that firm is using that tool without understanding just how invasive it can be. One of Kampala's top law firms. You want to talk about accountability. Think about what happens in the middle of a deal when that firm now uses that tool and something goes wrong. Right? As advisors, you take an agreement, you throw it in a tool and you say, give me an assessment. If you don't think through very carefully on what the implications are for that advice. I teach negligence at the law school, and one of my favorite things is to talk about the distinction between Hedley Bryan and Heller, and Caparo and Dickman. The role of advisors and liability for advisors. In the AI age, that question is a lot more complex. So if you think about, now I've gone ahead of myself because I'm trying to rush through an answer. So if you think about supply chain issues, if you think about the distance between audit and continuous assessment, and then the last one I'll touch on is strict accountability and the intersection between the physical and the digital world. I have suggested elsewhere in some of my writing what I call the physical impact rule. The French Civil Code has something that the common law does not have. The French Civil Code emphasizes a critical principle as the heart of everything. You know how in the common law we have innocent until proved guilty? The French Civil Code has this rule on do no harm. For us, in negligence, we say duty of care, and then we go from there to complicate and break down the thing. For them, they have one sentence, do no harm. What we call the neighborhood principle, how would that work in the AI context? Who is hurt by my actions when I use AI? Who is hurt by my actions when I by AI? Who is hurt by my actions when I build AI? If we are advising clients and we take that from the side of the consumer, and then we take that, we also now have to separate the entity we are advising from the deal. Because if I give wrong advice because I misuse the tool, the issue there is different. The point I am making is a simple one. The question is a complex one for which there are varied answers, and the answer really depends on who you're talking to, where you're standing. But my recommendation has been, we start by breaking down. One thing AI has done, I think, is to accelerate the rate of complexity in any simple issue. I mean, we just talked about braiding and whether, and the intersection between braiding and intelligence, braiding and communication, braiding and data. We look at a data leak as someone releasing a confidential document. When I hire lawyers at my law firm, I tell them, please remember that if you're sitting in a bar and you talk about the work we did because you are telling your friend how cool it is, we can get sued as a law firm. Because the example you use in an argument is somebody else's privileged information. Now, with devices that listen, how do you determine when the breach occurred? You talked about data privacy. You talk about, how do you determine when the breach occurred? When we talk about, oh, you know, there's this thing in almost every employment contract. Everything you do belongs to us as the employer. When this data is used to train a model, the complexity of the IP issues underlying that question, I think we all agree, are not simple. How does a breach occur? When does a breach occur? If I go to a data privacy regulator, if I go to the data protection office and I report a breach, how do I prove my case? The scientific, we are just dealing with a recent decision, a new decision, Silva Kayondo, on Nation Media and a tweet and copyright. And I saw his tweet last night saying, suddenly now everyone is an expert on IP valuation and data and this. And he is right. You just need to sit on Uganda's talk shows and you'll understand that actually our experts are very, very qualified, to put it gently. So that's why I'm saying that the only answer I can offer to your question is that what AI has done is to raise complex questions that require multifaceted answers. And as we build the answers, the best thing we can do is within the policy space, think at the architectural level, not at the consumption level, not at the risk level, because risk, I think, is oversimplified by many, many people. But I will leave it at that for now. Thank you.
Thank you. Thank you so much, Councillor Roberts. Appreciate. I will not even repeat that, except for the AI tool of braiding being creating more complexity than it should. The ladies would beg to differ, but that's a conversation for another day. Well, we cannot also wait to hear from the distinguished member from Kenya all the way. Welcome to Uganda.
Asante, thank you.
Karibuni. Am I right?
Yeah, you people speak Swahili as well. Eh?
Yes. So tell us about AI governance as it's becoming a board level responsibility. What core principles should guide African businesses in developing responsible AI governance frameworks?
Before I jump into some of the insights that I have, do we have any policymakers in the room? By show of hands. Policymakers?
Or even online.
Anyone who sits in a board? In the room? All right. So let's start from there.
Oh, may I remind you that we also have a virtual audience.
Okay.
Yeah, we did not greet them. And just in case they're there, you can answer her question and other questions following after. Thank you.
All right, great, thank you. So the reason why I asked that question to open the stage and set the scene is that we are often having these amazing conversations without the people that actually make the decisions at the high level, right? And we could gather all these insights. Maybe some of us sit on either technical advisory groups or either technical working groups, or either have an advisory role, and we'll compile all these notes. And then it gets lost somewhere in between from this stage all the way to a policy regulation reform or a policy being tabled. Are you seeing how the chain is being broken down, or where we are actually missing out? I sit in a board on the Data Protection Act in Kenya. It's called ODPCC. And I recently also sat at a training station, training the United Nations staff members for UNFPA on a thematic area called Technology Facilitated Gender-Based Violence. And every single thing that also my previous panel members have been able to share, it always comes up each and every time. Even what also Dr. had just shared from his previous speech is we don't actually understand how the data flows roadmap actually plays out. And when I'm speaking about data flows, from the point of data being collected, data being stored, it being used, how is the archiving and deletion phase happening at the end of us collecting data? And how are we also using it, right? Now, organizations across Africa, companies, businesses, we are still treating AI as an IT procurement issue. It is still sitting with the technical teams within the companies, within the businesses, right? But this is not only a problem at an organizational level, it is a capacity problem as well, right? So before we even jump into the regulatory frameworks, all these buzzwords and jargons, how about we start dealing with the basics? Literacy, digital training, capacity strengthening, capacity building, impact assessments, conducting the research around the existing gaps at an organizational level. It's very important for us to tackle all these buckets that are actually arriving us to the conversations around governance. Now, I won't touch so much on accountability because Doc has already also shared on that, but just to emphasize on the human accountability aspect. You see, artificial intelligence was existing, I think even about 5-8 years ago. There's so many banks, for instance, in Kenya, Cooperative Bank, Stanchart Bank, Safaricom, which is a mobile provider, service provider. We used to chat with bots whenever you go to a bank or especially a mobile app, right? Instead of you going to the bank and going to whether making your transactions or withdrawing money or seeking any service, you have a mobile app where you're actually chatting with a bot. That is artificial intelligence. So artificial intelligence didn't come with all this conversation about OpenAI, Anthropic, Google, Gemini, etc. and so on. It started way back, the automation. So before we jump onto the automation conversation, human accountability is very important because organizations and companies and businesses will be able to use this kind of more like a buffer model in terms of how we get to interact with the public, and that brings us to the conversation of earning public trust. As a business, that is very important. How will you get customers? How will you expand your business if you've lost public trust, right? The other aspect, again, it also brings us to the conversation of how do we get to manage data, how do we get to manage people, how do we get to allocate opportunities, funds, resources for important programmatic initiatives within organizations. And then how about to look at governance from an innovation, or rather an enabler of innovation, but not slowing down innovation. You see, when you talk about governance from a corporate governance level, or from a corporate high level, or from a decision-making kind of level, it always sounds as if it's something really heavy to be decided in a boardroom by directors, by the C-suite level, and so on. But this is where also so many bureaucracies are usually created again. They're coming with their documents, they're coming with their files, as Doc had shared, maybe on a quarterly timeline, for example. But they actually may not have the visibility of information that is coming up every other month or every other week. So again, it starts from that core principle of being aware. What's new? What are some of the AI tools that are actually there for this business or this company to use, or this maybe school, for example, or this institution? What are some of the biasness from this tool? What are some of the risks again? If there's any core principle that I always try to encourage stakeholders in every room that I walk into, the monitoring, evaluation, accountability, and learning framework, and the risk and mitigation framework, they're very, very, very core tools at the center of every solution that you're building. Whether it's a tech solution, whether it's an AI governance solution, whether it's a business solution, that always has to sit at the core of the basis of the work that you do. And then fairness that actually reflects fairness and co-creating solutions that actually reflect African realities. I was at a UN setting at the Geneva AI Governance Conference, and I actually shared that AI, I like to call it the African intelligence. Most Africans were the ones who fed so many LLM models, especially OpenAI. And when I type my name in an AI model, it tries to correct me because it doesn't know my ethnicity, my language, right? My mother tongue. If you try to ask an AI to speak anything in Amharic, in Swahili, in Zulu, in Yoruba, in Wolof, they aren't actually designed to be able to come up with such. But actually one hub is trying to get into that space. How many know an hub called Masakane Hub? Masakane Research Languages Hub. How many know it? You know Masakane? Great. They just launched last year. And they're constantly trying to bring the entire world, especially around African languages, LLM models that actually speak African languages. So realities of African people is very important. What reflects the African realities is very important. I know at the end of the day, we are always looking to eat, which is very fair and which is very much okay. But again, as much as we are building solutions to still reflect where the source of funds is coming from as a requirement, and in this sense, I'm speaking about donors, funders, and so on, because again, they always have their own agenda setting that they're trying to push onto the African setting, but they're not the ones who are actually on ground to reflect what actually transpires in real time. Right? So that's very important for us to have such nuances around building solutions and storytelling around African realities. Let me see if I've forgotten another point. I think that will be it from me. Thank you.
A round of applause for Lillian. Thank you so much, Lillian, and for reminding us to return to the basics, most importantly. Yeah, following that conversation, I would like to hear from Council Harold Turije. Yeah, you know, AI is being adopted much faster than legislation is evolving. So from a legal perspective, what should boards be doing today to ensure responsible AI adoption and also take direct responsibility for AI oversight?
Thank you very much. I had a deal with Anita that the harder questions would go to Dr. Chirunda, but I see betrayal in the camp. But for the speakers that spoke before me, thank you very much to the organizers. I'll just use two examples to answer that question. One, every one of us maybe heard about the case in the US where this teenager was chatting with an AI tool, telling it about his issues of life. And the conversation ended when the AI tool was advising the teenager to commit suicide. And the parent landed on it and somehow tried to sue this AI company. If you're advising a developer of such an AI tool and what they should look out for, that's a different conversation of a board that we can talk about. But two, there's an interesting case that I want to interest the audience in, Mobley versus Workman, still an ongoing case. Now, this gentleman called Mobley is like the doctor here, who was very intentional about litigation with AI. And in 2023, he knew that one of the companies was using an AI tool to sieve its job applications. So he applied over 100 times, and him and other colleagues who were actually black were not given any employment. He sues the company to say that it was biased, basically, that the tool is biased. How can I apply 100 times? And at the point of discovery, of course, it's at the point of discovery, I think they did discovery in April or June. Yeah, it's still ongoing. But think of yourself as an advisor of that board. When they were designing that tool, or telling a developer to design that AI tool, it's something that they didn't look into. For example, discrimination. But also think of yourself representing the service provider of the AI tool. Because incidentally, after they go against the company, maybe you might be added as a third party. So if you are advising the board on the issues to do with AI usage, it's very important for us to discuss that do not rush to adopt if you cannot govern. Like, that's the first beginning point. If you do not have the tools in place to say, I'm going to govern the usage of this thing. There's the KPMG survey on AI usage, and it was done in April 2026. And it actually quoted that 3/4 of the board people that were using AI tools had basic or no knowledge about AI. So if you are a board and you're advising to say, we need to bring on this tool to maybe solve one or two things. Doctor was talking about now a law firm that is feeding, because some of these most AI tools is you will just put all the documents, like the lawyers here in the room. I want to tell the partners that if you don't know how to use AI, some of the work that you're using, the associate used AI, like make peace with it. And they will just do a little bit and sometimes intentionally add mistakes so that you feel it has a human touch. But the reality of it is that they have used an AI tool. And sometimes they have just gotten everything that the client has given and fed it in a tool and say, please give me a legal opinion about this. But there's a record or a trail of someone's documents that have been left to, quote in quotes, an ungoverned terrestrial being, for lack of a better phrase. So it gets now to the board to know that if at one point a deal cracks because someone has accessed, an ardent user like Dr. Robert has accessed those documents by inquiring over and over into this tool, then data privacy comes in, confidentiality, breach of care comes in, and you can go on and on. Now, the test we usually use for the CareMark case on the roles of directors. As a director and as a board, you can be held liable for the decisions that you have taken or for lack of the compliance that you ought to have fulfilled. The Ugandan practitioners know that anything that is between our Companies Act from Section 80 on the roles of the directors, it is also imperative that if you're employing a tool or something that you're supposed to do, actually the case I'm discussing, the CareMark case, it's very interesting because the shareholders are the ones that sued the directors. In this matter where someone sued the hospital for asking for kickbacks from patients who are donating different organs and using the services of the hospital. The shareholders didn't know about that. The directors could not have known about that because it was just different employees. But after the shareholders and the company pays, I think $250 million US, they now come to sue the directors to say that in your responsibility as the board, you are supposed to oversee how these things go and move. And so you're personally liable. And the case, of course, was decided in favor of the shareholders. So if you're talking about the risk that is exposed to the directors in this AI age, you ought to take the lead. And if you cannot govern, don't even think about adaptability as a beginning conversation.
Thank you, Harold. Briefly reaffirming that if you cannot govern, do not even get started. Thank you for that. So before I leave you, Harold, adding on to that conversation, briefly also share with us how to prepare for future compliance obligations, you know, so that we can comply with the governance as you have put it. And while at it, give me one action that an African board, let's get regional, should take within the next 12 months to improve AI governance. What would it be?
Yeah, thank you. I usually advise clients in the most strict of senses. It's very important that for such a client before you, you use what's the most strict legal regime that is governing this thing that we are discussing right now. You would want to interest yourself, for example, in the EU Artificial Intelligence Act. And though it sounds very foreign, but it might catch any of your clients if they are selling a product or using anything that would be in the EU countries. Also, for local legislations, the Americans have the NIST framework. I know as lawyers we can debate whether a framework is enforceable or not. But the interesting bit with that framework is that it shows if you're designing an AI tool or you're going to use it, both, and Dr. was talking about either as a developer or a consumer, as a regulator, it covers all. Actually, America has even gone ahead. It has special legislation. It's actually a framework by the central bank on guiding financial institutions. So if you're thinking about usage and what to do, the legislation that is taking a lead is the good starting point. It talks about 1, can you identify the tool that you are making? 2, can you map and say that it's supposed to do A, B, C, D, E, it has this capability. We are not sure about A, B, C, D. And it's very important to know that they will never tell you everything. Even the person who's developing the tool for you, they will never tell you everything because we are a little bit limited with experience, and they will prey on our lack of understanding. I'm trying to be humble. I will not use the word ignorance, but on a lack of exposure for AI to basically be aware of these tools. So for example, the INST framework that I talked about, it talks about mapping. Can you be able to identify and classify the tool that you are using? 3, can you measure in terms of quantifying the risks, including the bias? 3, does it pass the local regulations? We had a recent case where our NITA was going heads-on with Meta on the application of our act vis-a-vis the policy for Meta. So if you are sitting on a board of a company that is, for example, in light of what Meta is doing, as a board, what are you doing to ensure that even the primary act that governs you, for example, in Uganda, while we don't have the AI legislation yet, we have data protection, as was discussed by our keynote speaker. Are you at least ticking that box? Do you have a committee in place to say, I have a policy on AI, this one is in charge, this is how we gather, we have an AI inventory to go with to say that data comes in and this is the history of it all through the usage of the process? That's one of 2 things that I can speak about to answer that question.
Thank you so much. I think Harold has really exhaustively handled that area. So let's go back to Brownie in a few words, but are clear to all. Tell us more about what governance structures organizations should establish to ensure proper oversight of AI throughout its life cycle. And while at it, in conclusion, you'll also give us one action that you think every African board should take to improve AI governance generally.
Thank you so much. I'm going to talk about the King Code 5, which is South African Corporate Governance Code, which right now is the one that is looking at AI technology, and it stresses that technology is the technology and all that happens within it is in the purview of the board. So that means whoever is responsible in a company is the board. So this beats the UK Corporate Governance Code of 2024, which does not really touch onto technology. So when they talk about Africans winning, I think South Africa is doing so with the King 5 Code of 2025. In regards to what governance structures should organizations establish for oversight through the AI life cycle? One, as I had already said, would have clear ownership. Who is actually responsible in the company for AI? Should we create, if it's a big company, is there a chief AI officer, or is it going to be under the risk and audit committee? Just as Dr. said, in regards to the risk committee and all this, is there continuous reporting? So with the risk registry to ensure that there's actually continuous reporting and overseeing. There's checkpoints during the life cycle. That is from pre-deployment, that is you deciding which AI tool as a company you're going to adapt in. And then during the work, as we are using it, what is happening? Then after, if we are going to stop using this AI tool, what are the mechanisms put in place in regards to our data and all that? So ensure that during the life cycle of that AI tool that you're using, you have checkpoints. So we know, like tracking progress, what is happening across. Then finally, it's to ensure that the management that is within an organization should be able to implement the AI policy. The committee should be able to monitor it, and then the chief AI officer should be able to manage the AI risk. So when you have those clear demarcations on who does what, then you'll be able to manage AI in the company. Thank you.
Thank you, Brownie. Well concluded. I will go back to Lillian before I come to Doctor. Yeah, after going back to the basics. So looking ahead, what practical recommendations would you give African businesses to ensure AI adoption strengthens innovation, maintains public trust, and complies with evolving legal and governance expectations? And of course, giving us that one action that an African board should take into consideration to improve AI governance.
Right, I had a few actually, but I'll be very succinct and straight to the point. Now, we have so many regulatory frameworks already existing. My colleague has already mentioned about the EU Act. We also have an African Union regional framework again around AI governance and ethics. Now, we need to move beyond that and actually now start being very serious about implementation. And when we talk about implementation again, I think to be very aware that we are actually, and especially at a board level, they may not have the expertise for this specific niche. So there's a need of actually bringing in a technical advisory group or personnel that sits within the expertise of AI and tech to actually work as a bed between implementation, between the companies, between the businesses, and now between and at the level of decision making. The other bit again, it's around, and that can work as an AI oversight again in the long term. Again, since the board, or rather the high-level directors are the ones who always make the decisions, they need to start thinking about investments, and investments in AI literacy skills, right, about capacity building and so on. Building on already existing impact assessments. So what are some of the existing gaps? Where do you need to close the loops? And how are we going to fill these gaps? That goes all the way back to investing in AI literacy, AI skills, and so on. And then just bringing the entire team on board. It doesn't sit with the board only. It doesn't sit with the advisory group or personnel only. It sits with everyone within the team. Because again, when data breaching happens, when the companies and businesses lose public trust, they will be held accountable, right? So we need to look at it from an implementation point of view, an execution point of view, and not forgetting the MNEAL, that is Monitoring, Evaluation, Accountability, and Learning Frameworks, and the risk and mitigation frameworks as well. That always has to sit at the core of the work that they do. Thanks.
Okay. Thank you so much. The applause died. Are we tired? Yeah. Lastly, first of all, Council, I apologize for not calling you doctor from the beginning. A very deserving new title.
Yeah.
It's as young as 18th July, so it's barely a month, I think. Congratulations, and I apologize. From now on, it's Dr. Robert Chiroda. Yes, so as we conclude, Doctor, tell us about the common mistakes businesses make as they integrate AI, and of course the one action that every African board should take to improve AI governance, and what would it be, and our takeaway from all this.
You know, I think you and Harold had a much more detailed deal. In addition to giving me the complex questions, you also agreed to give me the broadest. And that is unfair. But let us try. First of all, common mistakes. The commonest mistake I have seen is, I don't know how to put it correctly, assuming that this is tomorrow's problem. Or that this doesn't concern you, being aloof. I think it is the worst sin you can commit. I don't care about what industry you're in. I don't care about, I've seen it across the most sophisticated businesses. Tech businesses that you would imagine would have a much stronger risk register or more robust systems or more, they seem unbothered. And that troubles me. The second thing is in the distance between, allowing there to be a distance between employees and management on the one hand, and then management and board oversight on the other. Mm-hmm. There actually is, in some organizations, a strange silence. So the employees are using AI, but the organization doesn't have a formal position on it. Mm. That, I think, is a mistake. Be open about it and say, I know you're using AI. Let's talk about how you're using AI. Let's talk about safety. Let's talk about risk. Let's talk about all these things. A really good example I could use is one of the top US law firms, Sullivan Cromwell, got caught in a really bad situation. They filed a brief in a US matter in New York, and it was full of hallucination. What they did, which I think was brilliant, was they owned the mistake even before opposite counsel or the court could point it out. And they wrote and said, listen, we have an AI policy. We have steps we take. The policy was not followed. We will take corrective action, but here is the corrected brief. Now, I think that compared to all the law firms that we have read about that, got fined anywhere between 5,000 and 35,000 and 6-month suspensions and all those crazy penalties we've seen, the response here, even from the court, was different. Why? Because there are clear measures in the organization. A, to have the conversation. B, to engender accountability from the individual level to the organization. One of the most critical things that AI has done, in my view, is away from platforming and centralizing discussions, it has also meant that we must go granular, right? In the sense that when you're designing a risk register, it is not enough to say, is the tool biased? Mm-hmm. What does that mean? If we could do an event only on bias, and we'll have at least 9 different categories of bias, and what risks those present. Now, I don't mean go and write an encyclopedia on AI. It doesn't work. But be practical. The other mistake I have seen, my neighbor is right, underinvesting. We do this thing where we all know, everyone in this room, I am sure, would agree, it is better to use a paid tool than an unpaid tool. But we don't. When we are telling our employees that they need to use a paid tool, we don't discuss who is doing the paying. And I think that point, I don't need to take it any further. Now, to be fair, there is another issue. The cost, yes, the cost is falling, but it's falling in one side and rising on the other. So you need to think through, assess the cost carefully. Then there is the more complex question, which is, what do you buy? How do you buy? Where do you buy? When do you buy it? The very first assignment I did many years ago in my law firm when I was trying to enter the tech space, I went to a client who is a big financial institution and said, I'll review all your contracts for you and show you that a tech contract is different from every other contract you have. And they said, yeah, you could see they were taking the conversation out of politeness. They said, let's give you 5. I said, no problem. So they gave me 5 contracts. I reviewed them, wrote the report, and submitted it on what was wrong. Simple doc review, right? This was maybe 9, 10 years ago now. Here's what happened. When I sent the document, I sent it about 3 p.m. on the deadline. At 10 a.m. the next day, the head of legal called me and said, first come by the bank. So I went. And she had a stack of 46 contracts. And said, even these ones, how fast can you give us a report? No one had sat down, and I could see when I read it, you see there will be those things in the document and those things outside the document. I could see when I read it, the issue with all these contracts was there was no strategic consideration in the procurement of these third-party services. What are you buying? Where are you buying it from? What for? Right? So if you ask me, maybe so those are some of the mistakes I have seen in the people I've interacted, among the people I've interacted with, the organizations I've advised, large and small. Of course, when you're talking about government, that's a whole different other issue. When you're talking about non-profit versus corporate entities, commercial entities, for-profit entities, that's a different conversation. So depends again on who you're talking to about what. Now, there's one last one I want to highlight. I think we all, as different markets or industries, are making a big mistake which the Americans have learned to solve. We think very individualistically. As a law firm, I think about how can I use AI to gain the advantage as my firm, not as the legal industry. As a telecom, I think about what can I do to outpace my competitor. What some of the top labs are doing is they're saying, risk is risk. We can compete, but we face the same threats. Let's address the threats we face as AI labs together. But I want to suggest something even more radical. When you go back to the core of this, one of the simplest, oldest debates about the impact of AI, you essentially have maybe 3 or 4 categories. But on one extreme, you have those who are saying AI will take jobs. Right from the World Economic Forum reports to KPMG or the audit firm reports to the whatever, that risk is there. And then on the other extreme, you have those of us who believe actually that risk which you're emphasizing, it exists, but it's not the biggest of risks. And also, it is not new with AI. There were lamplighters in New York whose job it was to switch on lamps every evening at 7. I don't see anyone saying that because now we don't use kerosene anymore, oh my God, we lost lamplighters. It was a very important job. But no, I'm not saying it wasn't important. It really was important. There were conferences in New York 100 years ago about horse manure. How do you keep a city clean when all these horses are going dumping manure all over? There were conferences about this. That job is gone. Let's come back to the last 15 years, the last 20 years. When I went to work for the only law firm I ever worked for in law school, I started on 1 December 2005. The first thing the managing partner asked us on day 1, training session, He asked us, when you walked through the door, we were on the 9th floor of Greenland Towers. The reception was at the entrance after the lift, and you had to walk across the whole floor to go to the managing partner's office. We had the whole floor. And then there were offices on the sides, and the boardroom was actually in the managing partner's office. So you were passing people and offices all the way. He asked us, on your way from the reception to this desk, did you see a secretary? I did my internship at Shonubi, my clerkship, when we're doing the bar, for those friends who are not from Uganda, as is the case in all the countries. In Kenya, I think you have pupillage. Yeah. I think in Nigeria, you have pupillage as well. For us, we do clerkship for 3-4 months. Mm-hmm. I did my clerkship at Shonubi Soke. I'm very proud of that farm. I'm grateful to that farm. It's a fantastic farm. They had a typing pool. Let me tell you about the typing pool at what is now SM&Co. There were, I think, 3 or 4 secretaries. Those women were powerful. If you had a legal opinion which the managing partner was waiting for and you were in a hurry, you needed to understand that an emergency on your end does not constitute an emergency on theirs. So if it is lunchtime, it is lunchtime. You, the clerkship student who is trying to impress, that's your problem. You understand where I'm going with this? And then if you walked in and you thought, but I'm a lawyer, you're a secretary, God help you. Because they cut you to size with one look. They did not have to speak. The last time I was at SM&Co, I think the typing pool had been made an office. This is in my lifetime, this is in my career, and I'm not even done yet. Jobs have been going every day before AI became a thing. And jobs will go. What is the difference? The difference is this. I do think that generally speaking, and you can plant the data anywhere you want, between today and 10 years, 100 years, 50 years, the best way to predict the future is to look at the past. I think that if you draw an arc backwards and an arc forwards, and use AI as the major differentiator, AI will create more value in the economy than anything that mankind has ever invented. We can debate where the value goes, we can debate all the moral questions, we can get into UBI if you want, but the fact remains, AI will make people richer, wealthier. I worry, as a teacher of law from the law school of Makerere University, which incidentally, let me just try and piss off somebody here, the Nigerians and the Kenyans. Makerere is the best law school in Africa. Look, okay, now I'm just playing, but obviously, that's a question on which we will
Obviously, it's Nairobi University.
There you go. I was waiting for a reaction. But listen, on a more serious note though, I worry that for those of us who run farms, look, it's a serious consideration. I was at a conference in Zambia, over coffee, standing with a friend. He said, but how do you use AI? With 2 Ugandan lawyers in Zambia. We all left Uganda on the same flight. We went to Zambia for a conference. And then casually, one of them says, but how do you use it? I said, no, what I do is this, and I do this, and I do that, and I do that. The next day, we are both really sitting at different tables, but bored in this conference. So one of my colleagues walks up to me and says, so there is this sentence here. This is the task. Let's do it together using your approach. In 1 hour and 45 minutes, I had showed him how to use my 2 tools that I use the most. When I met him after 2 weeks, he said, the bad thing is you don't drink whiskey. The only way I want to thank you is to buy you the 2 most expensive bottles of whiskey I've ever seen. Because you have no idea what he did for me. He went and paid $100 for Claude a month. That's one of the tools. And he told me, I don't need associates anymore. Whoa. He's specialized in his field. He's the top guy in Uganda today. He does complex work. He does such high-value work. And he still has all his associates whom he had hired. But what has happened is the highest value work that he is doing, he is now doing alone with his laptop. I was examining orals at LDC 3 weeks ago. I couldn't help but worry for these people. Because what the tool has done is to avoid having to plant errors in an opinion by mistake, you just need sharper skill. The truth of the matter is, a person who has left LDC yesterday and I will use the same tool, arrive at different results in the same amount of time, only because I happen to have some experience that they don't have. Bridging those two worlds is the new first-class degree, right? Now, I think I've even gone off topic from the question, but let me conclude this and then I'll wrap up on the question. The thing we must discuss is how that affects not just the organization, but the industry. In other words, when we are doing our risk registers, we should have the risks relating to AI and the risks arising from AI that we must deal with. And what I'm suggesting is don't deal with it as an organization, as an individual, deal with it as a business owner, deal with it as an industry. In terms of what's the one thing we should all do, of course we should have a proper, where I differ from most people who say, have a standard, look at all the standards out there, is only you are the expert on what you do. And you are the only person who can define what you need. So define it yourself. What we can offer you, what my colleagues and I have said, and what we can all agree on, is that any framework we suggest will be a minimum baseline. And for me, the baseline has, for the framework has, yes, take everything that my colleagues have said. Harold did a fantastic job in summarizing for us the frameworks out there. Add to those the industry standards that are now emerging. Bar associations have industry standards for lawyers. ISO has a standard. There are all these industry standards that have emerged. And then craft your own version. The second one would be redefine how we do oversight between board and senior management. Set your risk appetite, receive periodic reporting on AI performance, incidents, and compliance, and understand that accountability is not only at the board or at the management level, but also at the individual level. The third would then be to have an AI inventory and risk, not just register, but also classification. And that also goes with rapid response approaches. What are you doing to respond quickly? Continuous impact assessment. My colleague was right in the sense that you cannot just assume that yesterday's risk is the same as today's risk, but also the impact of your risk and how you measure it. We were talking just now about data breaches and what those really, really mean. But also in terms of the way litigation changes. One of the things Silva Kayondo has, I think, has provoked all of us is how we litigate these things will change. When we appeared before the parliamentary committee, this is the last story, I promise. When we appeared before the parliamentary committee last year, I am also the convener of the Center for Law and Emerging Tech. And we decided, since they were revising the Copyright and Neighboring Rights Act, let's go and give them our views. My colleague Isabel was one of the people on the team. Isabel is here with me today. So we put our thoughts together and went to the committee. And while we were sitting in there, URSB was doing their exit meeting. And that is the company's registrar in Uganda. The Registrar General was there and she said, don't touch AI because it's too early for you to write this into the law. The Deputy Attorney General was there and he said, I'm curious what the professor is going to say. When my turn came, I said, let me simplify this. Let's use an example. How many of us like the song called Masavu? For the Ugandans in the room. That's a serious question. I want to see hands. So for the non-Ugandans who are visiting, please, and for our online audience, as a teacher, I cannot finish without giving you homework. Your homework for today is to listen to the two versions of Masavu. So what happened is a Ugandan artist did this really cool jam. I think it's a really good song, actually. And she's a fantastic artist. And then some kid goes home and decides, there is this artist who is now late. What would have happened if they had done a collabo with this lady? Because he actually, many people don't know that the late Mose Radio mentored Azawi. So he said, but this one was a mentee who has come of age. What would have happened if this had been a collabo? So he did a rendition using AI. Guess what? The rendition is more popular than the original. So I then said to the members of the committee, I said, listen, ladies and gentlemen, some of you here are lawyers, I know, because I taught them. I said, if you are a Ugandan judge and this lady comes with an infringement claim, what legal framework do you use to resolve the dispute? It is your role as parliament to make it easier for the judges to resolve these questions. And that's how we, eventually, I know for a fact, and to encourage everyone who's doing policy work here, I know for a fact that the committee then came back, the technical team of the committee came back to me and said, we are disagreeing on how to define what is copyrightable in the act. I was glad, even the Attorney General overruled them and said, no, we will do a specific law on AI, which was sad, but there was a victory. There was a team of 20 lawyers in the Parliament of Uganda who were debating how to write the clause that defines what is protectable and what is not. I think for me that was a win, in the sense that you have 20 people who had never thought about AI in copyright, thinking about the technical way to frame a statute. And I think that should encourage all of us to think about, and this is my parting shot, how we measure success in the way that we do any work on AI. Find your own way to measure success, and even when you're doing risk, and be grateful for even the small wins. Because for me, the big win would have been, yay, Uganda is the first country in the world to have a provision that defines what is protectable and what is not. Man, I was looking forward to that. And the parliamentary report, the committee report, recommended amendments to that effect, which got overruled by the Attorney General on the floor. The win for me was the current chair of that committee has made a firm commitment and said, we are not going to ignore this thing. At least the conversation is happening in that one space. Thank you very, very much. It was a privilege.
Thank you so much, Doctor. That concludes the end of our panel discussion. I wish we had the whole day. We could honestly go on and on and on. I couldn't bring myself to stopping any of them from submitting. It was that beautiful. I thank you. I thank the audience, those who are here physically, and the virtual audience back home and back in the office. Thank you for tuning in. Right about now, we are supposed to be taking questions, but I've been told that we are time barred, and I honestly, without bias, think that my panelists have really, really dissected and done justice to our topic today. But without maybe leaving it unfair, let's have one, maximum 2 questions, and then they'll be answered briefly. I see a hand saying no, the organizers, if they'll let me. Do we have a quick question from the physical audience? Okay, the questions I've got are from the virtual audience. I'm supposed to read them out, but I've been told to let it slide, that most of the questions have been somehow discussed. Okay, thank you so much, the panel, and I'll put everything back to the organizers. This brings us to the end of our session. Okay.
It's a privilege. The first panel has successfully dissected that discussion on boardroom accountability in the age of AI. I thank them so much. So we shall have the second panel on, and the topic will be who shapes Africa's digital policy, big tech, policy entrepreneurship, and the future of Africa's tech regulation. So I will invite the moderator to come, invite other speakers, then we begin as soon as we can. I see very worried faces. Lunch is going to come. Don't worry. I see very worried faces. We are going to have lunch, but I think it would be better if we have lunch after this panel, as we think about the discussions. Thank you so much. Those who are joining us online, thank you so much. It's a privilege to have you here, the first Big Tech Accountability Summit in Africa. It's a privilege for you to be here. Thank you so much. I'd like to...
I have to adjust the microphone. Good afternoon. It's such an interesting situation coming right before lunch. But I hope you are having a great afternoon so far and enjoying the discussions that we are having. The panel that we are getting into is going to be telling us who shapes Africa's digital policy, big tech, policy entrepreneurship, and the future of Africa's tech regulation. So I'm going to invite our first panelist, and that is Bonaventure Saturday. He's a research manager at Policy, and which is a feminist civic technology organization advancing digital rights, data governance, and inclusive technology policy across Africa. Bonaventure? Mr. Bonaventure Saturday. Thank you. Please give him a round of applause to our physical audience. Please just take a seat. I think you can sit right there. All right. So our next panelist is a lady I have the pleasure of working with, and that's Ms. Janice Celine Nantumbwe. She's the head of policy and research at the Center for Law Policy and Innovation Initiative. Please take the floor. All right, and then we have two other panelists that are joining us online. I'd like the tech team to just confirm that they can hear us. Okay, so we have Dr. Melody Musoni, who is a policy officer, digital economy and governance at ECDPM. She'll be joining us online. And then we also have Dr. Mark Gaffley, who is the director legal and operations at the Global Center on AI Governance. So again, please, a hand clap. It's although we're exercising now right before. So we're going to get into the discussion. I think I'll start with our physical panelists as the tech team guides. Right. All right. I'll start with Celine. Ms. Celine, could you please just tell us one thing about yourself and how this theme relates to you personally?
Thank you, and thank you, Zaina. Thank you to the BTA Summit. I think this is a very lovely platform and one that is timely. So as Zaina introduced, I'm the head of policy at a think tank called the Center for Law Policy and Innovation Initiative. One of the reasons we came up is because we noticed that there were no homegrown policy ideas coming out of Africa, specifically around tech. Of course, we had Research ICT Africa and a few think tanks around Southern Africa, but very few are out of East Africa. So why this particular topic is close to my heart is because I think as the youth, we have an obligation to make sure that African digital policy is shaped by us and by our ethics as well. Thank you.
Okay, shaped by us. Interesting. All right, Mr. Bonaventure, please tell us one thing about yourself and how this theme speaks to you.
Thank you very much. My name is Bonaventure Saturday. So this conversation comes timely, and why it resonates with me. In our work that we do, we don't want anyone left behind. All of us have been talking about these policies, these technical acts, but how about the person on the local ground is involved in this conversation? Thank you.
Indeed. I like that the previous part already asked if we had any policymakers in the room. And, well, it was very telling. So we have Dr. Melody. Thank you so much for joining us. Please just tell us one thing about yourself and how this particular theme speaks to you.
Mm-hmm.
I'm Melody. I work for the European Center for Development Policy Management, which is a think tank based here in the Netherlands, but we also have an office in Brussels. And I think we used to say back in the day that the future is tech, but I think tech is now, so we need to actually understand how technology transforms and changes our day-to-day life and activities. And if I can also ask for a special request, moderator, I haven't hard stop it within 30 minutes from now.
It's okay.
So we could start with the online panelists and to in-person panelists. I would appreciate that. Thank you.
Okay, that's noted. Don't worry, we'll take care of that. And then we have Dr. Mark as well. Hello, Dr. Mark. Thank you so much for joining us. Just tell us one thing about yourself and how this theme speaks to you.
So I'm in the media thing, you can see by the way I'm dressed, that it's very cold here in Cape Town, South Africa. But yeah, sorry I can't be there in person. It would be great to take a trip to Uganda. As kind of mentioned, I'm the Director of Legal and Operations at, the Global Center on AI Governance. And I suppose why the topic matters, I suppose it's in the title of the whole summit, rather, holding big tech accountable. I think it's a timely intervention and something that needs a bit more spotlight, but also more kind of nuanced approaches to how one can hold big tech responsible. So hopefully we'll surface some of that today or over the whole summit. But yeah, glad to be here and hope to provide some interesting insights.
Wonderful. So indeed, I hope at the end of this conversation we're able to indeed learn how to hold big tech accountable. So Dr. Melody, we'll start with you, of course, with your special request. The first question would be regarding, of course, your work with ECDPM. You have worked extensively on digital sovereignty, digital public infrastructure, and digital governance across both Africa and Europe. So who do you believe is actually setting the policy agenda today?
Thank you very much. I think one thing that we just need to acknowledge is that law and policy are usually reactionary, and we normally have or enforce laws and policies depending on technological innovations that we encounter every day. I'm not sure if you can hear me.
Yes, we can. Yes, we can.
Okay, thank you. So I think when we talk about Africa's digital policy, for example, we need to also appreciate that it's really responding to some of these technological advancements. And one of the reasons why, again, AI is a buzzword even in the policy or digital policy space is because of these technological advancements, and we need to make sense of what does AI implementing technology actually mean, how is it revolutionizing how we do business, how we engage and interact with each other. So even when you look at the history of the internet itself, when everywhere else digital infrastructure and connectivity infrastructures were being built, Africa was left behind. And that time again, even up to now, the conversation in Africa was really around closing the digital divide. And our digital policy landscape or agenda was really about how can we focus more on having digital infrastructure in Africa, how can we connect to the rest of the globe, and what kind of digital skills we need to have actually take advantage of the digital economy, and also now talking about AI. So I think naturally there is that understanding that policy, digital policy particularly, is responding to all these technological developments. But that being said, we also need to appreciate that there are other external factors that also shape how we are approaching the data AI governance agenda in Africa, as well as looking at Africa's agency. I think intimately, when we look specifically at Africa's agency, we can actually see that in some areas it's quite strong, in others it's a bit weak. So if you look again now, especially the conversation around digital sovereignty, there is definitely a shared or common understanding among African countries that the continent is really facing a new form of colonialism, a new form of data or digital colonialism. And the need for African digital sovereignty now is coming from a place where Africa and Africans have already noticed a lot of exploitation of their data and also of their workforce. And I'm happy that the keynote speaker also shared a bit about what the case of WorldCoin was doing in Kenya, which is just an example of some of the exploitation that is taking place in our continent. And of course, this type of exploitation at the hands of big tech is also shaping how we as Africans kind of navigate our digital policy landscape, trying to address some of the issues that are really affecting us as a continent. And that being said, we also, of course, we are not naive to external influence. I was happy with the lawyers who came before me who were talking about the GDPR and also talking about the EU AI Act, for example. And we know for the most part, Europe as the European Union, for example, as a regulatory superpower, has really managed to export or to influence a lot of African countries in how we shape our data and personal data laws and strategies in Africa. And of course, even I remember around 2013 thereabouts, I was still in South Africa, even at the time when South Africa didn't have the Data Protection Act, we were already referring to the previous EU directive on data protection. Even post when South Africa adopted the POPIA, which deals with protection of personal data, in 2013 and 2018 when the GDPR was adopted, still South African companies were also trying to see how does this POPIA, which came before the GDPR, align with the GDPR. So that just goes to show you the extent to which external factors, or especially external powers, have influence in how we as Africans actually shape or develop our digital policies. And then just 2 points, because I see I'm running behind time. I think there is a big role that even European development agencies play in the space, working more closely now with European development agencies like the likes of GIZ, France, or the Belgian Enable. We see a lot of them really supporting African governments on the ground, developing national strategies from AI, data strategies, even at the African Union level. The data policy framework, for example, it was developed, of course, with Africans at the forefront, but there was active involvement of some of these development partners, and we need to appreciate the extent to which they are actually shaping Africa's digital policy agenda. And the last point, I guess, I also want to make is really when we think about Africa's agency and agenda setting, especially now with the topical issue on digital public infrastructure, it's a new, I would say, a new policy area that was really pushed by India during its G20 presidency, and they kept on advocating it through Brazil's G20 presidency as well as South Africa's G20 presidency, even leading up to DPI becoming one of the policy areas to focus on, even in the Pact for the Future and the Digital Compact. So for me, what I found quite interesting is also, if you look at what's happening in practice, there's really a lot of money that's going from, especially from philanthropic organizations to support DPI. But then again, when you look at Africa's Agenda 2063, the Africa we want, and the digital transformation strategy that we developed in 2030, articulating what we want to work on in the coming years until 2063, DPI was not a priority. Yes, elements of it on digital ID are important, data exchange are important, but we already have our own foundational layers that we want to focus on. We want to focus on things like digital infrastructure. We want to focus on digital skills development. We want to focus on innovation. And these are, for us as Africans, the founding pillars that we need to focus on. And now, because everyone is talking about DPI, I'm seeing that conversation kind of shifting from what the digital transformation strategy really aims to do, and now kind of aligning with DPI, especially digital ID, which again, a lot of governments, the way they're approaching it you see they don't even have digitalized systems, but already they're pushing for digital ID. And of course, you start asking, like, what's the purpose behind having digital ID? If your systems are not even digitalized, what exactly do you want to achieve or gain out of this? So that goes to show you the kind of external influence that's also shaping how us as Africans are approaching some of these issues. And I'm going to stop there because I'm a bit time conscious and give it to the other panelists.
No, thank you very much for that. I think my key takeaways from your discussion have been, one, the policy is indeed reactionary. And then, of course, you talked about digital colonialism, the aspects on what actually entails digital sovereignty. And of course, the fact that we need to have our own foundational layers, our own pillars as Africa that we focus on when we are looking at shaping policy. So, Mr. Lee, this will move to you to just tell us a few things. So, of course, Dr. Melody has talked about different aspects when it comes to the EU, external influence, and we want to look at different approaches of digital regulation. And we have seen that the United States has largely favored a market-driven approach, right? And the European Union has adopted a rights-driven model when it comes to privacy, competition, public oversight, and all of that. So as African countries develop their own digital policies, should they be choosing between these competing models, or is there an opportunity to build a distinctly African regulatory framework that reflects the continent's own priorities?
Thanks, Zaina. So there's a politically correct answer, then there's a reality on ground, and I'll just piggyback off of what Melody said and also put it into context. The politically correct answer is we should make our own distinct laws, which are grounded in our realities and contexts, but we also know that the pressures that politicians and policymakers deal with, especially when it comes to digital policy, they are always going to be, they need to make sure that they have an answer or a solution in time. So if I'm to give an example of AI, and I think also Robert brought it up, if we know that we need to regulate AI at least in some manner or form, and you're telling a policymaker that you're supposed to figure out an African way to do it, how long is that going to take? It's going to be easier for you to go and benchmark, and I use that in quotes, off of what the EU is doing or what America is doing, and look at the standards that they have adopted and say that perhaps we can take this on. But where it becomes a bit, and I would say I also when it comes to policymakers, I also fault them on this. If you're given a template that is ready for you to implement it to your local laws, it doesn't mean that you should take it wholesale. So an example is the GDPR. When it comes to the EU, of course, we know that they had first mover status, so they had first mover advantage when it comes to regulating data protection and privacy. And they also let us know exactly how it should be regulated, which institution should take charge, etc. What our policymakers went to do, and of course because there was that pressure to regulate the way data is being protected, is they go and say, okay, the EU has already come up with a template, and then they implement it wholesale here. And we see the effects of that. We did not have institutions that were ready, we did not have the capacity, so what ends up happening is you have a law or policy in place, but it's not really speaking the realities of contexts. So to answer your question, I think we can do both. If we have a template to go on already, that's great, but we also need to exercise discernment. We need to exercise our brains. And the conversations that happen here shouldn't only stop here. As someone said, the policymakers should be in the room so that they also understand that people in Uganda have ideas as to how, let's say, AI should be regulated. And we can come up with almost like a mosaic of policy. Thank you.
That's interesting. So I think, again, what you're saying, that there's a very thin line between benchmarking and just copying and pasting.
Absolutely.
When it comes to policy. All right, Mr. Bonaventure, I'd like you to just take us, I don't know, to a different route altogether. As governments race to regulate AI and emerging technologies, should Africa's priority be drafting new laws or strengthening the institutions and regulatory capacity needed to enforce the ones that are already in place?
Thank you very much. We need the new laws, but we also need to strengthen our institutions. When Dr. Robert was talking, he mentioned about some model which escaped some lab, right?
Yes.
So what I got from that example is, oh, they are already trying to understand the AI systems they are having, right? So how about if Africa also has more of those labs, trying to understand the risk that AI comes with, trying to understand and learn from it? It would be good. But with these labs comes technical capacity. Do we have the capacity? It breaks my heart to know that the global AI talent, only 3% are in Africa. You can imagine. So how about we develop the capacity? We have more data scientists in the room. And also that goes to the policymakers, the judiciary, our lawyers here. I can bet if I asked how many people in their school learned about AI, all had a small model about AI in their law schools. All have tried to understand late after school. So how about in our schools we embed in some of these concepts so that we develop the capacity? How will judges preside over cases if they don't understand the basic concepts of AI? So we also need to do some part of judicial capacity. Then finally, the public, we need a public awareness. I believe laws come on board to protect the citizens. So how will the citizens be protected if they are not aware that they need to be protected? If they are not aware where to complain, how these models are affecting them. So to me, I think the three main points is having AI evaluation labs, building the technical capacity of our public sector and our judiciary, then public awareness. So once we have this and strengthens our institutional capacity, we are able now to bring in new laws. Thank you.
That was fantastic. You even gave the takeaways as well. So Dr. Mark, we are now speaking to you, and we have had from the previous speaker, they've been talking about working with development partners and the influence of the EU and all of that. And I think there are certain lines of cooperation there. So the Global Center on AI Governance published a report on cooperation on AI policy from global agendas to local action. And this particular report identifies cooperation as a pathway for global South governments to move beyond broad AI commitments towards coordinated action in areas such as regulation, infrastructure, and talent development. So from your perspective, what practical mechanisms are needed to translate these regional and international commitments into national AI policies that genuinely reflect African priorities?
Perfect, thanks. And I think just echoing something Dr. Melanie said at the beginning, speaking to sort of digital colonialism, something we're trying to, I suppose, guard against, and especially in this sort of context of big tech, is these, I guess, re-perpetuating these South-North relationships where we would have historical dependencies kind of being established again, and that would effectively lead to these kind of extractive processes where data, within the continent is being extracted outwards. So that's not the answer to your question, but just sort of reinforcing something that Dr. Melanie said that I think we should be cognizant of. But sort of responding directly to the question, we actually released a post on our LinkedIn yesterday on the Global Index of Responsible AI LinkedIn. And I think it articulates quite a good and progressive approach that was taken by the Nigerian government. So effectively what it did with its AI strategy is that it took the decision to develop a strategy based first and foremost on inclusion. And what I like about it is really a commendable, repeatable and practical approach that I think different African countries could also adopt. But briefly what happened is Minister Wilson Tijani, who is the Minister of Communications, Innovation and Digital Economy, said that his team worked to identify every person of Nigerian descent working in AI worldwide. And then they also mapped 20 years of academic publications by Nigerian authors and identified the leading researchers that were publishing in top-rated journals. And then they invited these practitioners back to Nigeria to help co-write Nigeria's national AI strategy alongside civil society, startups, and academics. So I think the point that this activity kind of underlies is a very much participatory approach where you can really go into identifying specific challenges and opportunities that local innovators are facing. It also represents a method of coordinated action and talent mobilization in a well thought out and targeted manner. So there might still be different, agendas and priorities of different actors in the room, but I think it's important to underscore here that effort was taken to ensure that the right people were in the room with policymakers. Another activity that I just wanted to highlight, which kind of goes to some of the work that TCG does, but we serve as the secretariat of a network called the Africa-Asia AI Policymaker Network, which has within the network policymakers from 5 African countries. So that's Ghana, South Africa, Kenya, Rwanda, and Uganda. What you mentioned that South-South cooperation document. We actually invited those policymakers to comment and provide input on that draft document, and I think that's quite a unique thing where we actually had policymakers helping us develop this document kind of in real time, so it's really informed by their opinions and not just us putting something together. But what I wanted to highlight about the network is really how it's sort of being fostered into this peer learning environment where different policymakers are able to communicate with policymakers from different countries and really learn, kind of on their domestic AI efforts, as opposed to having to seek input from established principles and, for example, OECD principles or whatever it might be. So I really like that as an approach that's really looking south-south and rather than south-north. And I think the nice thing there is that those different countries are obviously looking at local context, local interests, and yeah, that kind of I hope provides a kind of practical example of how we're going about with South-South corporations. So I'll leave it there.
All right, thank you so much. Again, my key takeaways there is having a participatory approach and coordinated action. And when you were speaking about this, you talked about the fact that you had policymakers in the room and they gave their opinion. And there's a whole other question there on how those opinions are formed, because what were they reading? What were they basing on to form their opinions? But that's a whole other discussion altogether. So I think we'll still go back to Dr. Melody. Yes, Dr. Melody, let's hear from you again regarding developing AI and digital policies. Should digital sovereignty mean writing our own laws, or should it mean owning more of digital infrastructure?
Yes, thank you for that question. I think digital sovereignty is really more than just having regulatory authority, right? Or having regulatory power. It's more than that. I think it's also about having control and power over the hard infrastructure and the soft infrastructure, looking at the markets and looking again at value chains, and especially looking now at AI value chains. So I think if you recall a few years ago, African governments really insisted on data localization, especially strict data localization, because at the time they thought that was the best solution to exercise sovereignty over their data and how their data was being processed. But of course, with time and of course through engaging with our policymakers, an argument was actually made to actually show that data localization doesn't always have these benefits, especially economic benefits that policymakers thought they had. And again, some governments were more receptive of that, and then of course the conversation shifted from strict data localization to being more open and liberal in sharing data. And I think what has also helped in shaping that is the AfCFTA Digital Trade Protocol, which also speaks a lot about the need for us as Africans to share data across the continent, and of course free flow of data. And I think the conversation broadly, globally on digital sovereignty now is really being shaped by the global shifts. I'm sure we all know how things are happening, especially now with the Trump administration, and the EU being one of the US's process partners has also been rethinking about what does sovereignty mean, because they also realize that they rely a lot on US companies. And I remember, I think it was in 2024, when a former European banker published a report that was called the Draghi Report. And in that report, he really pointed out the risks of Europe's over-reliance and over-dependence on external actors like China or the US. And as a result, the EU had to start to look into how can it reposition itself. And of course, this idea of EU's technological sovereignty is now focusing more on tech decoupling and prioritizing a lot on the growth of European tech companies and for how to support them to be more competitive. And I think that's just an indication, especially to Africa, where we also really strongly rely on US and Chinese companies, that we also need to change the conversation. How can we achieve digital sovereignty? How can we have our own African grown businesses that we can support and to provide that are leading on infrastructure development and that are providing ICT services to governments. So I think there is need for us to focus on the market itself. How do we as Africans actually support our own local economies, our own local businesses to make an impact in the African market? How can we support, of course I'm not being naive that we can all of a sudden replace the likes of Meta or the likes of Microsoft. It's going to be an ongoing process. And I think maybe one way of doing that is to promote more partnerships. Partnerships where we have big tech partnering with local companies. That way we are also gradually decoupling from over-reliance on some of these big tech that operate in our data spaces, in our AI spaces, for example, in our markets. But I think even on soft infrastructure, sovereignty there as well, it's also about the ability on how we influence how data generated from Africa is processed and how we create value from that data. And it doesn't benefit Africa to continue to use AI systems that are being built using data centers which do not always reflect African knowledge systems, which do not reflect African languages as well as cultures and values. So I think Africa is likely to improve its sovereignty by investing equally across the technology stack, not just focusing on regulation, but also thinking about how can we build our own digital infrastructure using local firms that we have, so that we don't continue to over-rely on external or foreign companies. How can we also support or strengthen our existing infrastructure, be it energy, for example? We really need to have energy security, because we can't talk about AI innovation without talking about energy, for example. Issues around skills is also part of that digital sovereignty conversation. We talk a lot about a lack of digital and AI skills in Africa. What are we doing about that? And even the conversation on the future of work, where everyone is worried about our jobs. How are we preparing ourselves for the future of work? What kind of skills do we need to already start imparting, especially young people, so that they are ready for the future of work? That's also part of that digital sovereignty conversation. Even the conversation around data, for example. How I was happy that someone was mentioning that South Africa has really been championing large language models, and Masakane is actually doing a good job. So beyond just LLMs, how else are we positioning ourselves in a way that we are able to generate more data and we are able to create value from the data that's coming from Africans? I think it's also part of that bigger conversation on sovereignty. So in other words, sovereignty is just going beyond, it's not just about the laws and policies, it's also looking at the whole technology stack, from the infrastructure discussions to the skills that we need to have, to, of course, touch more on the policy that we need to have and the enabling environment that we need to have. And then just to end there as well, I think someone had already pointed that earlier, we need to focus again on regional cooperation. The whole idea behind Agenda 2063 3 and the AFCFTA is we don't want African countries to work in silos. We need to promote regional integration and regional collaboration. Even now, within the conversation on data centers, we can't be in a situation where we are insisting on each country getting from data centers. Perhaps the solution we need to have is infrastructure shared with regional clouds. If you are in the ECOWAS region, maybe it makes sense to build data centers that can serve ECOWAS, data centers that can serve the SADC region. And this idea of a data embassy, which is now slowly coming up in the policy conversations. Estonia has done it. They have their data hosted in Luxembourg. Why can't we as Africans start thinking about that? Nigeria, South Africa, Kenya, they are the leaders on data center markets in Africa. Can we think of how we can build on our sovereignty by locally hosting our data in some of these hotspots that we have in Africa? So I think I'll just ask.
All right, thank you so much. I think you answering this question on digital sovereignty has also left us a lot to ponder on. Since you have a hard stop, I'd like to just give us your parting shot, and then we'll hear from Dr. Mark after you. Dr. Melody, are you still with us?
Yes, would like to hear
your parting shot, because I understood you had a hard stop.
Okay, I think my parting shot would be, I think from the conversation, I was trying to promote having our own African grown solutions. So I think it starts with our governments. We know our governments are they are the biggest consumers of digital services and products. So if we are really serious about digital sovereignty and tech decoupling or reducing our reliance on these big tech, then it starts with procurement, right? If we can make it compulsory for governments to start procuring services from local firms or making it compulsory for big tech to collaborate with local firms when they provide services, I think that's a good way to also start promoting our own African solutions.
All right. Thank you so much for being part of us today and for sharing all of those different aspects that we need to indeed think about and see how to implement locally. Dr. Mark, the question goes to you now. When it comes to regulation, again, how can governments regulate dominant digital platforms without creating compliance burdens?
Perfect, thanks. I might be in danger of disagreeing with Bonaventure on something he said before, but I think different opinions in the room is always a positive thing. I just think generally with technology solutions and AI in particular, there's a kind of narrative that's put forward that the tech can't be regulated because it's moving too quickly. And when you actually try and unpack that, you kind of think, well, artificial intelligence, at least the algorithms, etc., underpinning them, they remain relatively unchanged from formulation like 60 years ago. So we might have new use cases, but the actual way that the tech is being developed is not necessarily as fast moving as the narrative kind of makes it out to be. So that might be a contentious thing to say, we can discuss and debate it later, but I'm just putting that out there before I kind of respond to your question more directly. So kind of with that background, something I always kind of like to say, and it kind of links to that phrase, if it isn't broke, don't fix it. And so it's like, does a particular rate of technology actually require new legislation to regulate it? And I think that's an important thing to ask, because, for example, with a lot of digital technologies, a country might already have established consumer protection laws, privacy and data protection laws. There might be competent competition authorities that can kind of keep big tech in check. Labor protection laws, etc., that already regulate these spaces. And so if you introduce another law, that might complicate it or muddy the waters, if I can call it that. So the thing with these existing laws is that they may already be local and easily understandable for local innovators and startups. And this would be especially so if they've kind of been in place for a long time. And that will also keep the playing field level if you're not introducing new and complicated regulation. If we have an extra regulatory step, for example, having a law regulating the use of artificial intelligence, the dominant players with their established compliance or legal or policy teams and their development teams are really kind of at an advantage because they have these teams that can pivot much more easily than your startups and your innovators. So something that I think remains key here is also, I kind of spoke to it earlier, that kind of co-design and collaborative participatory approaches to policy making, and to ensuring that all stakeholders in the room can kind of debate what is necessary to include and regulate, etc. So two quick parting points in this question. The first is that if you kind of take it back a step and kind of go a little bit tangentially, government procurement process with digital technologies, you might run the risk of kind of vendor knock-in law. I spoke earlier about north-south dependencies, but you could develop these dependencies on dominant foreign providers, which would ultimately give them a lot more bargaining power at the negotiating table. So just being aware of that when you're procuring these specific technologies. The other thing which has actually disappeared from the South African tax system, but we used to have something called Section 12J tax incentives for venture capital investors investing in early stage startups. And I think mechanisms like this could be quite useful in the kind of digital space as investors, especially those who kind of got this experience building background, likely have the requisite experience to know how to navigate compliance questions. So if they're incentivized to invest into startups, they obviously bring all their experience and know-how with them. And that could just kind of, bring up the skill level or knowledge base for these startups and these innovators without having to have to actually hire an extra experience. And obviously the nice thing for the investors there is that they're incentivized through tax breaks, etc. So just a kind of practical angle for addressing that.
All right, thank you as well, Dr. Mark. If you could also just give us your parting shots in this regard.
Yes, I did also have a bit of a hard stop as well. So I think just framing the kind of question that was asked for the hard stop is if Africa could make just one policy of institutional change over the 5 years, over the next 5 years, that would strengthen its ability to shape its own digital future, what would that be? And I think the other key effort is figuring out how to ensure that skills were retained in the country, or more broadly on the continent. So currently we kind of have this low interest in south-south mobility pathways compared to, for example, your south-north options. So we really need to think about ways to create incentives for local professional opportunities and attractive living environments so people don't sort of seek greener pastures elsewhere. We already have kind of AR visa and incentive programs as one kind of option, but I don't think these should simply encourage people to work locally. It should go a bit further, because what you find, for example, with these kind of digital nomad schemes is that people come from the global north to work in local context, but they're still working for their foreign-based companies. So if there's a way that we can kind of ensure that there's these visas when they're granted, there's a requirement for local skills development or something. And then it just goes without saying that any policy that's enabling local STEM education, skills development and training has the potential to really move the needle here. And from a technology perspective, I also think there's value in exploring edge AI and offline solutions, as these will kind of help expand access to learning, bearing in mind the associated costs with using digital technologies. So that's my final part. Just remember the kind of education angle. That really is critical. And with that, I'll hand it back. And if I disappear from the call, I do apologize. We've got another again.
No, it's all right. Thank you so much for joining us. Again, to the people in the room and our online audience, I think a key question that he has left us with is, does every new technology development require a new regulation? So I think we need to think about that as well. Thank you so much, Dr. Mark, for joining us, and Dr. Melody as well, just in case you're still on the call. If there are any questions that come in the chat from our online audience, please just handle them before you leave. So we're back. I hope the chairs have been comfortable. Are they? Okay. Mr. Saturday. I wanted you to just speak to, because we already discussed the African realities and shaping African policies, just one more note on how African policymakers can ensure that the future AI and data governance frameworks are shaped, again, by African realities. And then from there, you'll just give us just one recommendation that would most strengthen Africa's ability to shape its own digital future.
Thank you very much. I think we need to domesticate these laws. When we look at the European laws, they are very good. They give us the starting points, the principles to start with as we develop our laws, but we need to have our laws which are based on our African realities. So governments need to invest in local evidence generation, and I'm happy that the Ministry of ICT already has innovation beds. If you go to Nakawa, the ICT hub there, there is an innovation bed whereby if you have your technology, your ideas, you want to test them out there, you can come and they support you from a controlled environment. So if you can have more of them, we can be able to generate more local evidence. And number two is the principle of Ubuntu. I am because we are. Most of these European rules are based on individual protections, right? But in Africa, our reality is that we are a community. We deal in communities, right? So we need more laws that can protect us as communities because that's the reality that we have. Then finally, we need to adopt a bottom-up approach, right? The laws we make need to start from down, from the local ground. If I give you an example, if any one of you has gotten loans of Weole, More Cash, or etc. So the amount of money you get is not determined by someone. It's a system, an AI tool that is seeing the money you're sending, it is seeing the people you have in your contacts, the money they're sending. So the amount of money you get is determined by a system. So you might find this system is neglecting some people, it is increasing the economic gap, right? So how are these realities going to be embedded in the laws that we are having? And I'm glad that the Ministry of ICT now that is coming up with our AI strategy, it has consulted the communities. I remember they went to Kavare, Gulu, and Solota, I think, to get their perspectives. And we hope that when it comes out, it will be based on the African realities, the realities that we have in Uganda.
All right, thank you very much. Celine, last but not least. What should Africa's digital policy ecosystem look like over the next decade? And what role should government, industry, academia, civil society, and think tanks each play?
Okay, this is a big question, but we can keep it short and sweet because
Yes.
people are hungry. Some are checked out. But I think, first of all, we need to agree that government cannot work in a vacuum, especially when it comes to tech policy. When it comes to all policy, to be fair, but especially tech policy, because it's private sector, it's the companies that are making these tools that are directly seeing the dangers actually before even the public does. So for me, I think at least with the public sector, with government, they need to act independently, avoid regulatory capture, but also be willing to learn from the private sector and the companies. And I think America does this quite well. The NIST framework that was spoken about earlier was a collaborative effort between private sector and public sector. And why that worked is because private sector was seeing in real time, these are the dangers you guys should watch out for, and this is how we should regulate them. So I don't think it's something that we should look down upon, to think that they have bad incentives. They don't really, not all the time at least when no money is involved. So yes, for governments, be independent, but avoid regulatory capture. For industry, I think, especially with tech, we are seeing a lot more of them self-regulating, which again could be a good thing or a bad thing. Set guardrails in place as government, but allow private sector to test out these solutions before they are implemented. And I think Anthropic is doing this quite well with, it's called the Glasswing project, I believe, where they have given the AI to companies and seeing how it's going to work, especially because it has a lot of risks of cybersecurity. And they're going to be able to now go back and implement those guardrails. So when they do find out that stuff, they should go to government and tell them that this is how you guys should think about regulating this particular model. With civil society, as always, civil society keeps the public sector accountable, but also the private sector accountable, to make sure that things like ethics are implemented into these laws, to make sure that, just like what Bonaventure is saying, to make sure that things like gender are implemented into these laws and policies. And then for think tanks and academia, which play similar roles, is to come up with novel ideas, especially in the context of Africa. We need to be coming up with our own solutions or trying to see how we can be able to mix and match something that works for Africa. Thank you.
Thank you very much. A round of applause to our panelists. I have the feeling there are no questions because we are between you and lunch, but our panelists will be in the room. If you have any questions at all, please just share them, approach them, and they'll be able to answer them. To our online audience, please, if you could just put that in the chat, we'll be able to respond to them accordingly. Other than that, thank you so much to our organizers. Thank you for inviting us and for having us, and thank you again to our panelists. Have a great afternoon.
Good afternoon, ladies and gentlemen. How was the sessions? I believe you people enjoyed and have learnt and relearnt and unlearned some things. So it's now time for lunch, and we are going to return at exactly 3. We're having our lunch for 30 minutes, and return at 3. We have another important, not to miss panel session for you people. Kindly requesting that Shiba Ganyana Pasi leads us in prayer for the meal. Yes.
Hello, everyone. Let's humble ourselves. Heavenly Father, we thank you for today. We thank you for this gathering. We thank you, Lord, for enabling us to be here and have these wonderful discussions. Lord, as we go to have our meal, we ask you to bless the food, bless the hands that prepared it, and bless the mouths that are yet to eat it. We ask all of this in Jesus' name. Amen.
Thank you very much, Shiba. So we're having our lunch at Coco Restaurant. Coco Restaurant is below here, next to the swimming pool. Enjoy your meal. See you at exactly 3 p.m. Thank you.
Going to put it here.
Good afternoon, ladies and gentlemen. Welcome back from lunch. I believe you enjoyed your meal, but above all, you were able to meet a new friend, communicate, and connect properly. I have a question for you people. What do mattresses, cockroaches, peanut butter, and rats have in common? Should I repeat? What do mattresses, cockroaches, peanut butter jars, and rats have in common? Any guess? Zero. I see. Anyway, welcome back from lunch. Someone called Brownie is going to talk about it. She is launching a book called Law, Life, and Laughter. Wouldn't you want to hear about this? Brownie, you're welcome. Please come and tell us more about your book. But in the meantime, people seated at the back, please come in front. I believe that people who are not joining us for the afternoon session, so it would be better if you allocate so that you do not miss the afternoon session. Thank you.
Lol. Hi, everybody. My name is Brownie Ebal. I am going to be launching my book called Law, Life, and Laughter. It is a witty memoir of finding faith, failure, and purpose. It talks about my childhood to my university days, and it looks at how I was able to choose law. I wanted to be a medical doctor, but then the experiments with cockroaches and dissecting them made me think otherwise. So I ended up in the legal profession. I am into corporate law, and I'm inviting you to come for the book launch. It's on Friday, 4th September. If you want to buy a book, you can come. If you want to buy tickets, there's an online link we'll be sharing with the admin of this conference. And I'll be glad to see you there as we discuss finding purpose from different minds, both legal and non-legal. Our guest of honor will be Honorable Balam, and we'll be at Silver Springs, Mbuya. Thank you.
I just happened. Good afternoon, ladies and gentlemen, once again. How are you people doing? Welcome back from lunch. I believe you enjoyed your meal. And this afternoon, we are having a very interesting conversation. We are going to be talking about inside the investigation room, how African data protection authorities took on big tech. Isn't this the reason as to why we came here? I feel like that's the main reason as to why we came here. So we are having Counsel Bakesi Jasper. He's the managing partner at Cavern Bridge. He is going to be the moderator of this session. He's going to be moderating the session. Counsel? You're welcome, sir.
All right, thank you all. We are now starting session number 3 of the Big Tech Accountability Day 1 session. So this session is mainly going to discuss, the topic is inside the investigation room, how African data protection authorities took on the big tech. So as you can see, the topic is insightful. I'll now go ahead and introduce our panelists. We have Mr. Baker Birikuja. Mr. Baker Birikuja is the Personal Data Protection, he's the director of the Personal Data Protection Office in Uganda. And this is a body that is the most consequential in investigating any complaints against the big tech. So I will invite Mr. Baker Birikuja, the director, to please take his seat. Our second panelist is Mr. Olumide Babalola, doctor. He gave us quite an insightful address in the morning. I'm sure most of you will agree. So we are going to have another opportunity to hear from the vast knowledge he has about investigation. Then I'm still confirming whether Ms. Mercy Mutemi, the Executive Director of the Oversight Lab of Africa, will be joining us online. The tech, oh yes. Thank you very much, Mercy, for joining us. You could please make a virtual wave to ensure that, you are in the space with us. Mercy? All right, thank you very much. I'll now join the panelists and take over the session. All right. So as we go into this insightful panel discussion, I will begin with from home, Mr. Baker Birikuja. Thank you very much for joining us, and we are very pleased to have you at the Big Tech Accountability Conference. So my first question to you is, and which I know that the panelists have, or rather the participants are very eager to hear from you, is how, behind the scenes, if a complaint is brought to your office, if a complaint is before you, how do you sit down, investigate, and make sure that you come up with a well thought out decision against the complaint? Please take us through.
Thank you. Good afternoon to you all. Now, I should first start with talking about the title of the panel, Taking on Big Tech.
Yes.
From the office perspective, we do not take on companies because taking on brings about that visual of you're in a ring there is one party here and another, but rather what happens is we receive a complaint, and this is what I'm going to take you through. So just like any other complaint, say digital money lenders in Uganda or a big tech, once we get a complaint, the law provides the form that should be used. Those forms are usually submitted by email, some through formal letters, others can even just walk in without even knowing what that form is. So we are guided by, we have an internal document, a complaints and investigations manual, that standardizes how we deal with complaints. That whether it's a small company or a big tech, as long as you're dealing with the regulator, it's a standardized way of receiving your complaint. So the guidance in there is that once a complaint is received, we first go through it to determine whether it is a complaint about a matter that is governed by the Data Protection and Privacy Act. So that we do it by looking through the facts, if there is any alleged breach, violation that has been stated. So once that is clear, then the office moves into another element. We receive a number of complaints, so at that point we triage to determine what should be dealt with at what point in time, because there are already others that are already in place. So if it's public interest, looking at the number of data subjects that will be impacted, the level of harm, then it goes way up on the waiting list. Now for this particular one, with the big tech, the very first one was, excuse me, was against Google. Now that one, it was mainly around cross-border data transfers and registration. So once we get the complaint, then we follow our regulation that talks about conducting the investigations following the principles of natural justice. So we write to the other party, letting them know we've received a complaint and giving you an opportunity for you to respond. Now when that respond or even amicably settle. So if the other party, we are able to get them, if they're registered, it's a lot easier. We have their contact details and physical address, we can write to them. But big tech and the two that we've investigated, they have no physical premises in Uganda. So it would be to send them an email and letting them know of what the complaint is. So once we hear from the other party, they share their evidence, then we come back and see whether if it has been amicably resolved. If it hasn't, then we come back to the party and see what additional evidence we can get from them. Once all that evidence has been obtained, then we determine some evidence given. Do we need to have it under oath? Then we can invite the party to come in and have their statement recorded. We have 2 police detectives attached to the office, so they can record such a statement, or it can even be done virtually. So once that evidence is obtained, we've heard from the other party, then if the other party needs to make a rejoinder, we allow them to do so, of course, within the period provided for in the law. Then that information is gathered and the decision writing starts. But most of the work around with the big tech, and even any other, but specifically with the big tech, it's not at the point of gathering the evidence and writing the decision, but what happens after. Being a regulator is not just about issuing a decision, but it's about changing behavior, a culture, or seeing that compliance being done. So once the decision is issued, there is a lot of work that goes into ensuring that actually whatever has been decided on, the orders made, the declarations provided in there, they're actually followed. There is another whole process that deals with that. What the public usually sees, just 10%, the decision, but in having that change effected, a lot happens after it's issued. Thank you.
Right. I think briefly, Baker, if you don't mind me just making a brief observation, it appears you sit as a quasi-judicial body where you are able to adjudicate a dispute.
Sure, we do.
All right, thank you very much. So later in your discussion, you shall be telling us about the landmark ruling that you delivered in the matter of Sekamo and others versus Google. You know, and I think there was also another matter, Adligo International versus Meta. You will later on tell us a bit about those. So let me now go to Dr. Olumide, Olumide Babalola. So there is the famous Femi Falana versus Meta. Yes, which is a matter I'm sure that you are, very, very instrumental in handling. It has generated enormous interest. Our panelists and our participants would like to know what are the critical legal principles that anyone interested in litigation against the big tech, not in the matter of Femi Falana versus Meta.
Okay, so thank you once again for the invitation. So when we started, or before we started that case, I needed to lay this foundation so that it can clearly answer the question. So before that time, African courts mostly, or even some parts of the world, they had always seen privacy from a very narrow perspective. If we ask anybody, the general thing we would say about privacy is in fact, the way we say it, don't intrude my privacy. So we understand that privacy is an intrusion. And, but there are other privacy interests, or there's other areas of privacy that we always neglect. In actual fact, there are 4 areas of privacy, but the courts all over the world, with the exception of few, maybe some courts in America and some few parts of the world, they have touched the other parts. Intrusion, everybody knows intrusion. Easily the courts, easily the regulator, easily even the violators of privacy understand intrusion. The other part of privacy is the use of image right. Also in some jurisdictions, image rights has only been seen as a copyright issue. But even universally, copyright does not necessarily protect, or intellectual property does not necessarily protect image rights. No. Intellectual property protects invention. So when you create something, that's what intellectual property protects. But your image, you did not necessarily create your image in the technical sense. For example, somebody comes in here and takes your picture. The picture is your image. You didn't create it. Even though you might say, oh, you were the one that dressed up the way you wanted to be seen or something. But creation of that, your image, no. Somebody else did, and they could use it to advertise events, they could use it to advertise products. And in the past, the privacy jurisprudence did not develop enough to be able to protect that as part of privacy. But thankfully, Nigerian courts, maybe about maybe 6-7 years ago, gave decisions that image rights are actually protected under the right to privacy. So that has no controversy much. The third one will be publication of embarrassing facts. So these are facts about you. Then somebody publicizes them. You won't be able to sue the person for libel. For example, let's assume there's somebody in this room who has tuberculosis and nobody knows, but somehow somebody gets to know and publishes it. You can't sue the person for defamation. The person hasn't defamed you. The person has actually stated something true about you. But privacy protects that. Like, even though it's a fact, but these are private facts that I want to keep private. Courts in South Africa, and I think a few decisions in Kenya, they have identified that. In fact, one of the very interesting cases was a woman who did IVF 19 times. She had IVF 19 times and still did not have kids. It was a private fact that she kept. But then some newspapers publicized it. And of course, the court identified that as privacy. The fourth one is publicity in a false light. That one, I've seen many people discuss it or discuss the case, but not actually, because these are, privacy is just, even all over the world. Privacy is an emerging concept, even all over the world. I mean, I have spent 3.5 years of my life studying it,
And I can see how developed and underdeveloped it has been all over the world. The fourth one was what I litigated. And many people did not know that it was my PhD that made me litigate that case. Nothing else. While I was doing the research, I discovered, there's nothing like this. And I wanted to write on it. So I needed to create it one way or the other for me to be able to write and do my research on it. So, even in South Africa, in a decision, it was mentioned in passing. So that is what we litigated. Now, the applicant found on Facebook that there was a video of him, deep fake video of him saying that he was healed of a terminal illness by a hospital. He didn't do the video. It wasn't him. His image was superimposed. Even the voice, if you listen to it very well, you might possibly know, especially if you know how he speaks, you will know it wasn't him. When he reached out to me, the first thing that came that he wanted us to do was libel. I said, sir, no. If we were talking about 6 years ago, if you had spoken to me that time, I would also agree with you it was libel. But with the research I have done, with the discoveries I have made, even though it might be libel, but there is something else that gives us better results than libel. And it is privacy in a false light. And that's why what exactly we litigated. What that part of privacy protects is somebody projecting you in a false light. Somebody giving you false publicity. And we have used it even before that time, but because it's meta, that's why it got really viral. So that's what we litigated in that case. And happily, the court agreed with us. But some of the issues that also came out was, first of all, like many people have argued. And that's why sometimes when I see argument, I say, come, there's a point of doing research. There's a point of reading up. There are certain things about privacy data protection, honestly, you can't use residual knowledge. There are certain questions they also ask me, or places they ask me to come and speak. I do research first. So that, because these things, Nigeria started data protection in 2019. Europe started in 1970. Germany. So they've done 60 years. They've done 50 years before we even started. So there's a lot for us to read, and there's a lot for us to interrogate. So I just told them, you will read it up, and then you will see why this is not necessarily libel. In fact, in our case, we told the court, it was in my argument, it was in the written document we filed in court, that we are not claiming libel. So let's get it clear. We are claiming privacy in a false light. First of all, there are few elements you have to prove. First of all, and well, many issues came out from it. There was a publicity of the applicant by the respondent. And the publicity paints the applicant in a false light. That's what never happened, or saying what is untrue about the applicant. And the applicant felt hurt, he felt damaged by it, and then he approached the court. So several other issues that came out would be platform regulation, platform liability, which are, of course, there are new areas that the law is developing, even in Europe. Now, for you to adequately be able to touch on that, then you have to look inward. You have to look inwards. What regulations do you have in your country that speaks to platform liability? Happily, Nigeria, what we call National Information Technology Development Agency in Nigeria, issued a code of practice for these intermediaries. Because I don't want to take too much of your time, but the fact that you are an intermediary who has a platform does not mean you can just easily say, oh, I am an intermediary, then I have no liability. There's a case I will speak to when I speak next, so that I won't take too much of your time, but I hope I touched a bit of some of the things you asked.
Oh yes, you did. As a matter of fact, what I noted is there is need to make a proper distinction between personal data breaches and the common law tort of libel.
Yes, definitely.
Thank you very much. So we'll now go to the representative of the Oversight Lab Africa, who is online. Please, for the benefit of our participants, you will tell us your name one more time, and also enable us understand the Kenyan TikTok petition and how that petition was able to be handled in respect to, data rights. Edward, we can now hear from you. Oh yes, you are audible. Irene, sorry for interrupting. I hope you can project your voice a little louder so that our participants are able to hear.
Okay. Can you hear me now?
Oh yes, we can now hear you. Yes, that's good enough.
Okay, thank you so much. So the TikTok petition was in 2023 and it was presented to the parliament by the public. It was about the banning of TikTok in Kenya, but that moved from that regulation of TikTok. So beyond the main concerns in this petition were the harmful content that TikTok was entertaining in its platform by not taking it down and having, enforcing community standards to make sure that people are protected online from harmful content that included harassment, violence, and even explicit content. So with regard to data protection, there were very many concerns with regards to how TikTok was collecting personal data, and especially for children without age verification mechanisms, and how it was using this data and transferring it to third parties. So the committee that was handling this included several regulators, including the ODPC, which is the Office of the Data Protection Commissioner here in Kenya. And there was a big task of, just being able to balance between the freedom of expression versus the right to privacy and protecting people online. Of course, the argument against, banning TikTok was that, banning TikTok would actually have economic losses to people, and especially young people who are already depending on TikTok as a platform, as a source of living, and the creators who are, creating content on TikTok. And we can all say that TikTok is actually completely harmful without any benefits. We have seen so many benefits from economic, social, and even cultural benefits from the platform. But then being able to balance that right of expression with the right to privacy and the right to not cause harm by, amplifying content that is suicidal and violent and, has his speech is what, is a big task for us. And the Office of the Data Protection Commissioner was actually tasked with, or rather offered recommendations that were to ensure that TikTok is compliant with the Data Protection Act, which is a Kenyan law that governs privacy of users. So ideally, some of the key concerns and recommendations that TikTok has to ensure that it complies with is one, ensuring that processing of personal data is with regard to the data protection principles that are set out in the Act, as well as the data is processed lawfully. And this extends to some of the principles such as principles of data minimization, principles of purpose limitation, principles of data minimization, just ensuring that the data that is collected by TikTok properly is as necessary and not too excessive. Of course, there are concerns that TikTok as a platform based on users' data through algorithms rolling over the accounts and getting information such as accounts details, behavioral data, such as somebody's liking a particular content and so based on particular content for that activity. And how is this data that is collected that we use for? Is it used for personalized advertising? That commercial use of personal data should only be with the consent of the person and not just because it was collected. So those are some of the recommendations that the ODPC offered to just ensure that when TikTok is operating within the country, it complies with the data protection laws, and that people are also protected online from harmful content, because ideally the aspect of course harmful content belongs data protection, but again it's a very key issue that came out because TikTok as a platform already has community guidance or other community standards that, are against harassment and violence online. So why is it that, especially for Africans, these community guidelines are not enforced? So it really shed light to how sometimes these big tech companies do not invest in proper content moderation across Africa to protect their users, and they mostly rely on automated decision making, or even content moderators who are not very well protected. We have seen that especially in Kenya, where the people who are operating the content online are not protected, and that it leads to poor content moderation and content moderation that is not context based with our language and cultures.
All right, thank you very much, Irene, for that presentation. Now, before I head back to our panelists, I would just want you to identify for us about 2 challenges that have really encumbered ordinary Africans from getting remedies against the big tech companies in case their data and their data privacy is breached.
Thank you so much. I'll start with the biggest problem, which is the jurisdictional problem. We have seen this quite a lot in the cases that the oversight lab has litigated against big tech companies. That there is the issue of jurisdiction, because most of the tech companies are, of course, from the Western, and they do not have residents, or they are not incorporated in the country. And what that really means is that they use the business process outsourcing structure, where the instance data can outsource another company to do the work for it here in Kenya. So when a breach happens, then it becomes very problematic, because the people here are not able to go for the business process outsourcing company, because they think that it's not, it's not like the employer and that Meta is the employer. We have seen that quite a lot in the cases that we have litigated, where Meta asserts that Kenyan courts actually do not have jurisdiction over this, because it's not, doesn't reside here. So that is one main problem, but at least for our Indian courts, we have cases from the Court of Appeal that have asserted that we are able to sue big tech companies here, which is a win for us. Another big challenge that we have seen is lack of public awareness and political goodwill. Because most of the times, even when the violations happen, the public sometimes are not aware of their rights and not aware of and what policies to apply, especially because our sector specific laws are really just trying to catch up with the technology, and especially when some of the violations are from big companies that have a lot of power and influence of our government and policies, it becomes a bit hard for people to even be able to seek redress.
All right, thank you very much, Irene. I think our participants also agree that jurisdiction is one of the main problems Africans face when taking on the big tech companies, which is a point that Dr. Babalola was stressing this morning in his address. Anyway, now I'll go back to Mr. Birikuja, the National Personal Data Protection Director in Uganda. So, Mr. Birikuja, there is at least 2 main petitions which your office has handled. They are known in the public domain, that's Sekamo versus Google and Adligo International versus Meta. So we would like you to take us through how the investigation challenges that you faced while handling these particular matters, and how you were able to overcome those investigation challenges that you were faced with at the time.
So the first challenge, what the previous speakers talked about, is around jurisdiction. Google doesn't have offices, physical offices in Uganda, neither does Meta or WhatsApp. So the earlier explanation that I gave how we handle investigations is that you give the other party an opportunity to respond. But here we were faced with respondents that didn't have premises in Uganda. So the very first challenge is we needed to locate them, but not even just to locate them, but locate the right person to respond. So that challenge impacted on the investigations. They went way longer than the period provided for in the law. But even then, when you get to the company, say a representative, as the regulator, to get to the that individual or that particular department that will provide the response may take a while. Now, these companies are large in scale in the sense that decision making can take a while. So you have people across the world who need to make a decision and get back to you. People who have different working cultures, ways of understanding the problem, and even how to deal with it. So that's a very big challenge in regard to conducting the investigations, and yet you have the complainants expecting or reminding you that it should be concluded within the period provided for in the law. As the office, we didn't decide to just have an empty chair whereby you have a complaint, you don't hear from the other party, and just issue a decision ex parte. So that has been a very big challenge, and it's not unique to Uganda, at least most of the African countries where these big tech do not actually have physical offices where you require response.
All right, thank you very much, Mr. Bidikuja. I think if I'm to follow up on your presentation, you know, despite despite the disputes involving the big tech companies, has the data office in Uganda received any cooperation to whatever extent when it is brought to their attention that there is a dispute in which they must respond? Have you received any cooperation from these companies, if any?
You're putting me on the spot about the question of cooperation. But anyway, the decisions are public documents, and it's clearly provided for in there that for some of the respondents, we didn't get the first cooperation we had anticipated for the reasons that I've given. But actually, these big tech companies, from my experience, they are very cooperative when you get to the right offices. They are willing to go through the complaint, provide the evidence, and also even address the challenges. So to help you understand better, based on the two, is that, okay, many people talk about the two, but there is actually the third, which I believe it was in 2024 or thereabout, OpenAI. So OpenAI, you know, having these technologies, which was also in Kenya, around, you know, the orbs which they are using to collect data in regarding to developing technologies. So they are cooperative. They were also cooperative at the time because we gave them an order not to continue processing data of Ugandans until certain mechanisms are put in place. Then also with Meta, WhatsApp, I'm actually happy to report that what we ordered them to do has actually all been implemented. We asked them to have a Ugandan-facing privacy notice. It's actually live. We tested it. Then we asked them to provide clear mechanisms around consent. Now, these mechanisms, they developed a feature called the Trust Center, whereby if a person needed their data from WhatsApp to be shared with other products of theirs, say Threads, Facebook, and the rest, you needed to actively consent and allow the linking of the accounts. So they've been cooperative to the extent that when we asked them that, you know, this privacy notice should reflect the Ugandan law, they did it, and it went live in regard to the clarification, increasing transparency, which would put more information control. That was done as well, and again launched in Uganda. Then Google eventually registered, and they even provided documentation around all the other orders that we provided for. Now, the cooperation, what we noted as the regulator, that they are willing to go ahead if they are given information of what is required to be done. And this information comes in form of decisions. If it is well reasoned, if where there is evidence is properly balanced and weighed, and where something is found lacking, it's clearly provided for. So in short, if they see that the process is objective, well reasoned, and even where they were not complying, they are willing to correct that, and definitely all that comes through the cooperation.
Thank you very much. At least we've now known there is a bit of cooperativeness from the big tech companies. So I'll now go to Dr. Babalola. The question I have is, of course, a bit legal and technical, but I'm sure that you're very able to answer it. Very many African countries have developed legislation that is modern in respect to data protection and privacy. But why is it that when there are disputes, the outcomes are not exactly the same, even when the laws of, I would give an example, Uganda, Nigeria, and Kenya, they are common law countries. They have modern data protection and privacy legislations, but the outcomes differ, especially when they are interpreting, those legislations. What do you think causes that issue?
Thank you again. So when I spoke earlier, I gave a background as to when data protection started in the world and when Africa caught the bug. Even though Cape Verde, they were the first country to have data protection law in 2010, but it's a new concept that we were not all used to, and we are all also trying to get used to it. You see concepts like controller, concepts like processor, what processing means, the responsibilities, the principles. First of all these things were imported. All. Interestingly, we have, and remarkably, we have some African countries that are devising their own jurisprudence or their own legislation just to give it a little bit of difference. During my presentation in the morning, I made allusion to South Africa, who have they have the concept of responsible party. We've also seen Kenyan legislation, interestingly, their own definition of sensitive data. They have family, either family name or family details, which is critical for Africa, because Africans, certain things in the family, we find it sensitive than the West, from where we copied these things. For example, in my tribe in Nigeria, they usually say that they don't count the children for someone, meaning you shouldn't normally ask someone, how many children do you have? That's the tradition we grew up with, until there was a day my driver wanted to go on vacation, and I told him, okay, so now that you are going on vacation, you are coming back in another 1 week. And I said, but please, how many children do you have? The guy said, no, Oga, they don't count children for. I said, sorry. Me, I actually wanted to give you $100 per child. But since you said I cannot count the number of children, I'll just keep my money to my pocket. They said, no, Oga, I have 3 at home, 2 outside. So, so that's the African culture that we're used to. But abroad, anybody can tell you. In fact, there was, when I was doing masters, one of our teachers, very good lecturer, very intelligent man, he would say it openly that he had been married 4 times. He would say it, that even the 4th one, he had divorced the woman. Normally, these are not things we say easily in Africa. So, borrowing European concept, then we should know that we will have many teething problems. Unfortunately, we can't have it all. We have borrowed their laws. Sometimes we might want to look to them for interpretation, but we can't do that every time. Because, for example, another example is sensitive data. In their own definition of sensitive data, financial data is not there. I live in the UK. Financial data is not sensitive to them the way it is sensitive to us in Nigeria. For example, if you want to buy anything in the UK, you're buying it online or on the phone. They will call you and ask you to dictate your credit card number. They will ask you to dictate, you will dictate. They will ask you to dictate the security code at the back, you will dictate. And they might, some of them will ask you for your password, you will dictate. And they will take the money they need to take. And the balance is there. I've been doing it for years and they have never taken my money. I imagine doing that in Nigeria. So we all know what will be the consequence of that. So they did not put financial data in their own definition of sensitive data. And we copied them. We also did not put it. We also did not put financial data. Meanwhile, financial data is more sensitive to us, even than sexual orientation. I mean, we can't even relate with sexual orientation. So that is why we will keep having, until until the law can really develop to a certain, and I'm thankful that in Nigeria this year alone we've had at least maybe like 20 or 30 data protection decisions on different areas. We've had on consent, we've had on data minimization, we've had on implied consent as well, we've had on transparency, on fairness. I mean, this is how it grows. And sometimes, in some cases, I have had to cite foreign authorities in court, and the judges will come back to say, yes, you have cited these authorities, but you understand that they are just persuasive, and we will have to apply them the way it is applicable to us and the way we can understand it. So yes, even though we are Africans, but you know that we also differ in our culture. I mean, we might have the general Ubuntu culture, yeah, but there are still some few things. For example, many times I want to do something here, I would ask, is it permitted? Can I do this? Can I do this? And you say, okay, yes, I mean, here we don't have a problem with that, you can do this. So even though we're Africans, but we still, so definitely we are going to keep having some difference in decisions. Number one, until we have local precedents that we can reference, local decisions on similar issues. And number two, until we begin to have Africa-wide jurisprudence as well, that we can cite and we can use. I've been searching, and maybe this one that we keep having conversations like this, we can all take it upon ourselves to improve the jurisprudence such that we can have many data protection decisions across the continent that we can cite. And also don't forget, people discuss these things and people posture. Anything that is new, people can really subject it to many kinds of interpretation. I was surprised when I was reading a particular court judgment, and a lawyer made an argument in court. The judge recorded it in the judgment that somebody's photograph, a Nigerian lawyer, somebody's photograph is not a personal data because the photograph does not have biometrics to identify. I struggled with it, but I mean, we will continue to have this until the law really develops to a certain point where certain arguments cannot be made. Also, we still have some funny arguments that lawyers still make here and there in Nigeria, and I'm so sure some other African countries, but until maybe the final court makes certain decisions, and then we can lay it to rest. So we will keep having them, and even though we can say all the laws, they are similar, there are a few overlaps here and there. In some countries, you require authorization. In Africa, you require authorization for cross-border data transfer. You have to go to the regulator. I don't know if that is also applicable to you in Uganda. You have to go to the regulator to seek authorization before you can transfer data. But in Nigeria, no. There are some mechanisms or some safeguards. And also across Africa, I've been looking for it. Clear definition on, and that's why we continue to have this problem. Certain concepts are not clearly defined. For example, if we say cross-border transfer, not many legislation, even Europe, should struggle with it. What exactly does it mean? If I send an email containing my photograph to an entity in the UK, is that cross-border? If I want to buy a card, I want to buy ticket, airline ticket, I'm in Uganda, and I want to buy ticket from Rwanda, or even from Kenya or from Nigeria, and I have to impute my card and my details, is that cross-border transfer? So there's certain things that we need to, and I say this with all sorts of responsibility because I'm also involved, there are certain things we have to deliberately go out of our way, forget whatever we inherited or forget whatever we copied. We have to deliberately go out of our way as a country, as a jurisdiction, to clarify these terminologies. Otherwise, we will continue to have these divergences. Thank you.
All right, thank you very much, Dr. Babalola. Irene from the Oversight Lab Africa, as we close this session, I would just want you to address one thing for our participants, and that is, please take us through what regulators, in Africa can do to show that they are more proactive than reactive, especially when certain data breaches have been performed against the citizens. Of course, I would expect you to give us that brief in line to the TikTok petition in Kenya. How can regulators improve their reaction towards, breaches against the citizens. Thank you very much.
Okay, just confirming that I'm still audible.
Oh, yes, you are.
Okay, thank you so much. So I'll still start by saying that most of the times our regulators, are active and, they respond to data protection issues when, the breach has already occurred. I'll give an example with the work for case also, for instance. This was a case that, the ODPG actually, the Data Protection Commission here in Kenya, actioned after, IB's accounts of so many were already been collected. And most of this data, but especially biometric data, it's very hard to tell, a company to do it and the right to what it becomes very blurry given this of technology. So this is really what calls for a proactive rather than a reactive approach where we firefight when people's human rights have already been violated. And that is also what happened with the petition for the ban of digital in Kenya. The collection of data had already been ongoing for the longest time. Harmful content was already staying in the platform for the longest time, and we were reacting only after people have already been harmed and started complaining. So to ensure that we are very proactive in how we approach these issues, my first recommendation would be using the Data Protection Act, especially the requirement for data protection impact assessment document. That requirement for having data protection impact assessment to analyze all the risks and potential mitigation mechanisms in case of data breaches is really important and relevant, especially in the digital era, where we ensure that before systems are brought to our country, we ensure that a data protection impact assessment has been done, and we do not license any big tech companies to conduct any activities and projects in our countries when they have not conducted that impact assessment and submitted a report to the Office of the Data Protection Commissioner. So we need to be very aware of what is going on as regulators so that they are able to ensure that there is compliance with that plan. Another thing is conducting audits. Most of the systems and algorithms go unchecked, and there is a lot of opacity and lack of transparency on how systems and social media platforms are operating in our African countries. Most of the times we are even not aware of how the algorithm works, or when we are not aware of how our systems is working, it's very hard for us to be able to regulate it. So the first thing is to ensure that we understand, we have access to information and all the algorithms and the systems that are being used to collect and process personal data in our countries. Adhere to the explainability and they are auditable. We can conduct audits not just at the entry of these systems to our countries, but also regular audits to just ensure that there is continuous compliance, because just looking at the terms and policies that the tech companies offer is not enough. That is something we have actually seen in TikTok. They have private policies, they have content moderation and community standards, but are they enforced? And it's very hard for us to know that these policies are not being enforced if we do not conduct regular audits to their systems and require them to explain the algorithms and how they function and how they collect personal data. And the last recommendation would be multi-sector collaboration between different sectors. That petition, the TikTok petition really showed how there were so many concerns in different sectors who have been involved to just ensure that this kind of violation would not have happened. There is a role, of course, for the competition and the communication with regulators to work together with the Data Protection Office, just to ensure even at the end point of entry that the systems and the big tech companies are compliant over domestic rules. So those would be the first recommendation I would go over to just ensure that we are not being proactive. And again, most of the big tech companies rely on the fragmentation of our laws as Africans to be able to exploit whether data or even resources and humans. So to just ensure that Africa, some of the African countries do not look like they have weaker laws, or they don't look like havens exploitation. And we have seen that a lot, especially in some tech companies moving from one country to another when they are when the laws catch up with them. We need to work together as Africa, as East Africa, regionally, and even continentally, just ensure that we have frameworks that are not fragmented and we can be able to hold tech companies accountable altogether.
All right, thank you very much, Irene Mukau from the Oversight Lab Africa. Thank you for your discussion. I also want to thank Dr. Olumide Babalola for your kind insights, for this panel today. And lastly, I would like to thank Mr. Baker Birikuja, the National Data Protection Director at the office here in Uganda. We have now come to a close of this session. I'm sure that you have, taken out a lot of insights, and our knowledge and appreciation of data protection has increased. My name is Bakesi Jasper, Calvin Bridge Advocates. I'll now ask one of our organizers to come and take us to the next session. Oh yes, we are now having a photo session with the panelists, and thereafter, one of our organizers will come.
Good afternoon, ladies and gentlemen, once again. Welcome from the first afternoon session. Without further ado, before that, let's clap again for our speakers. They did quite a fantastic job. Thank you very much. Let's welcome our next panelists. We are going to be talking about the regulatory overlaps. Regulatory overlaps and tough wars. When too many agencies regulate the same platform. What comes in your mind when you think of such a topic? Anyway, allow me welcome Mr. Joel to take us through the next panel session.
Thank you. Good afternoon. Namgira Joel Peter is my name from DPO Private Center East Africa. As introduced, the topic for the next panel is regulatory overlaps and tough wars when too many agents regulate the same platform. As we may understand, digital platforms today are simultaneously regulated by multiple regulators, from the Data Protection Authority to the Competition Authority, tax, consumer protection, among others. These various regulators are meant to protect the customers or the citizens. But the question is, what happens where we get a friction between how they operate? So this session is intended to look into insights on how African regulators can move from fragmented enforcement towards coordinated digital regulation while maintaining institutional independence. We have a panel of 3, of whom I'll proceed to introduce. Our first panelist is Mr. Otieno Davis. He oversees compliance and investigations at the Uganda Personal Data Protection Office, the PDPO. His work involves ensuring compliance with Uganda's Data Protection and Privacy Act while engaging with other government institutions. He's a lawyer with over 10 years experience and is a certified compliance and risk management practitioner. He also has experience in public policy and governance, energy, and data protection. Let's welcome Mr. Otieno Davis. As he gets to the floor, our second panelist is Mr. Collins Dimacaso Mashile. He's a senior regulatory policy and legislative expert and public sector executive with over 20 years of experience in digital platforms, communication regulations, broadcasting, digital platforms, competition, and consumer policy, and also legal outlooks for artificial intelligence, spanning the ICASA, which is the Information Communications Authority of South Africa, the Department of Communications and Digital Technologies, and Global or International Digital Regulatory Returns. He will be joining us online. Thank you for joining, Collins.
Thank you very much. Thank you.
Okay. Then our third speaker is Mr. Ifeanyi Okonkwo. He's a partner at the prestigious Pan-African law firm, Stillwaters Law Firm. He's a fellow and vice president of the Standards Committee of the Institute of Information Management, the body setting certification standards for data privacy officers in Nigeria. He has advised multiple national, regional, and local companies on complex transactions on data privacy and protection. He has conducted over 150 data privacy audits and trained over 40 companies. Welcome on board, Mr. Okonkwo.
Thank you very much. Nice to be here.
So as we cannot, time is not on our side, so we'll be trimming our discussion to just a few questions within the time we've been provided. My first question will be going to Davis from the perspective of the regulator. Many digital platforms fall under several regulators simultaneously. From your perspective as someone at the Personal Data Protection Office, where do you mostly, frequently encounter judicial overlap? In just 2 minutes.
Thank you very much. With regard to jurisdictional overlap, as was stated in the previous session, tough wars sometimes arise because of, first and primarily because of a fragmented legal framework that we have in Africa, particularly in Uganda. You realize that there are various national legislations that provide for regulatory entities that are meant to enforce different aspects. And data protection is something that is embedded in very many aspects of day-to-day life. So jurisdiction overlap mostly comes from our perspective as PDPO. We have encountered challenges when dealing with our digital money lenders. Those form part of the digital economy, as well as with telecom companies. So because 40% of our case portfolio has digital money lenders as the most flagrant violators of data protection principles, and they're the ones who are most often the ones carrying out unlawful disclosure and unlawful processing of personal data. And they have their sector regulator, which was the Uganda Microfinance Regulatory Authority, that has now been rationalized and subsumed into Ministry of Finance. But previously, when it was an independent entity, we had instances where we were required to collaborate with UMRA, the Uganda Microfinance Regulatory Authority, because this is the primary regulator of the digital money lending entities. With regard to telecoms, we have had complaints brought against telecom companies, and this of course has necessitated the collaboration of the Personal Data Protection Office with UCC, Uganda Communications Commission. So, but those two form a smaller extent of the complaints that we receive as the Personal Data Protection Office. So in terms of challenges, of course, the regulators, every regulator wants to be seen to be doing something. about whatever it is that they're supposed to regulate. And as PDPO, we're also a regulator of regulators. We're a super regulator, so to speak, because data protection, as I said, is embedded in each and everything. So even these regulators, the ministries that regulate, then the various MDs, the departments of government that regulate, or like Ministry of Finance, Ministry of Trade, because Ministry of Trade is also a regulator for competition practices. They monitor competitive practices, and they must give approval for mergers and acquisitions in the country as well. So PDPO is supposed to regulate all these other ministries and entities as well. So we find that dealing with the regulator on a one-to-one basis, primarily because you need their help in ensuring that the people that they regulate, that they oversee, comply. And then at the same time, maybe they're also in a violation. Perhaps they have not renewed their annual registration. So navigating that is a bit complex, but we have seen goodwill from most of our sister and brother regulating entities, and we currently have collaborative frameworks with about 4 of them. That is the National Lotteries and Gaming Board, which is in charge of lotteries and gaming, that is sports betting and all the like. We have an MOU with the Insurance Regulatory Authority, which is the regulatory sector regulator for insurance. Then we also have MOUs with UCC, the Uganda Communications Commission, and with I think there are 4. But we're going to roll this out eventually to other sector regulators. Thank you.
Thank you very much for the insights. I'll be moving to Colin. South Africa has several institutions that regulate the different aspects of the digital economy. How does your government, or how should government look at coordinating these agencies to avoid a duplication? In just 2 minutes. Thank you.
Thank you very much for the invite, and thanks to the colleagues in the room. I've been following the debate, very interesting. So, in South Africa, we have economic regulators, and in the economic sector, you have a cluster of ministers that are responsible for the economic sector, and you also have regulators like CASA, that regulates telecoms, postal, and broadcasting. Then you have Competition Commission and the Consumer Commission that are dealing with consumer issues and the issues related to competition. You also have a information regulator that deals with what we now call data protection and other issues. And you have a Financial Conduct Authority that deals with financial matters, and you have a Gazette that deals with domain names. So what our colleagues have done in the sector is that they have formed what is called ICT Regulators Forum. And that is, I think, a good lesson where the coordination is happening at the regulators level. And this, as you can know, most of you will be aware, has been happening at the Global Regulators Forum at the ITU. But now, since the emergence of digital platforms, I think the colleagues have been learning from the Digital Regulation Corporation Forum in the UK. And you also have that Global Digital Regulators Forum network, and also your Global Online Platform Regulators Network that deals with children protection and online issues. So, in our country, what we have done in terms of the coordination, because these regulators are independent, this association of regulators is largely governed and led by the CEOs and the chairpersons of these organizations, and then at arm's length. In the coordination, I think most of the time, from our side, it's recognized in the law that all the regulators and self-regulated organizations are doing as part of the regulator. So, from our side, I think what we have done is that we are trying to ensure that there is coordination, because for you to do the coordination, it means that you will be responding to a request from operators and your global platforms that are saying that they will not wish to various regulators, they want coordination. But what it also does is that when there are matters that are overlapping, the regulators, currently they are having their own memorandum of understanding or of cooperation. So the regulators will see and decide that this matter will be dealt with easily by you. For example, let's take the measures and acquisition my colleague was talking about. When there are matters that are cutting across broadcasting and telecoms and other issues, you'll find that the Competition Commission, because there's more powers, they will deal with the competition matters. And then the other related to broadcasting will come from the element of broadcasting. And the ministries will coordinate among themselves to say what will be their views. But the views will be determined by the current operating laws. So there is that coordination in South Africa. And I think because it's at the beginning, it will work as it's trying to align with global development. Thank you.
Thank you, Collins. I think one thing comes out clearly that coordination is very key within regulators if we are to avoid any overlaps. It's not any different from the insights shared by Davis. I'll move to Mr. Okonkwo. From the perspective of practitioner, as well as that of companies operating in digital platforms, what challenges arise when several regulators investigate the same issue? We are keeping it the same time, 2 minutes. Thank you.
Can you confirm if you can hear me clearly?
Loud and clear.
Thank you very much. So there are actually several challenges that they face. In the course of my work for some of these multinational and regional companies, I've always tend to see the same similar complaints from these companies. I will summarize them into 4. One is that there is the issue of duplicated demands and reporting standards. The second one is there is conflicting expectations, and let me just quickly talk on the 2. The first one, which is duplicated demands and reporting. Imagine a multinational company has to deal with all 54, let's say about 34 African countries, maybe because certain regions have the same law, right? So otherwise we're talking of they are dealing with over 54 several duplicated demands and reporting standards, and they have to review for every country. And we are talking about digitization, we are talking about globalization. Even in a particular country, for instance, in Nigeria alone, you find out that they will have to deal with different agencies, like you have the NDPC, you have the CBN, you have the FCCPC, and then you have NITDA. NITDA is the National Information Technology Development Agency. So if you then find out that it's a whole lot. We talk of conflicting expectation. This particular agency or authority is expecting that you fulfill certain metrics. Now, some of those metrics might be, confusingly and dissimilar to some other expectation by another agency. And you see, it's very difficult for multinational companies because then they will have to keep a whole lot of reporting standards, separate standards, because and in fact some of them sometimes have even thought about should we just close out certain jurisdictions and say we are not offering services to those jurisdictions. But you see, you find out people want them and they need to still scale. Then you talk about multi-clients. Imagine if one of those companies there's a data breach or perhaps, and of course when I say data breach, now we are talking of perhaps external threats, which is normal if you understand how cybersecurity works. If that happens, what you are now facing is you have to face a fine from Kenya, you face a fine from Ghana, you face a fine from South Africa, provided you are dealing with all the data subjects in those countries. And so it makes it quite cumbersome for them to do business. And then there is also the fourth one, which is reputational and operational distraction. Of course, let's even leave the reputational one because for big brands, everybody wants to take a bite at them, right? But what about the operational distraction that, of course, because each time you need to keep to certain standards and reporting standards, especially when they are conflicting, then you now have to keep doing that fulfilling all those standards and metrics up until you are done with all 34 countries just in Africa alone. And if you think about that, you find out that this challenge are quite overwhelming. And that is why there is a need for Africa to sit on the table and find a common solution.
Thank you, Okonkwo. We won't go any further beyond that. The discussion portrays just one thing I can point out, that coordination within the regulators is very key, and it requires them to take a proactive approach just beyond what the law provides. They need to do it themselves and engage each other to see how best they can work together without clashing and fighting for who manages what. Yeah. Thank you very much, Davis. Thank you very much, Okonkwo, and thank you, Collins. Back to the MC.
Wow. Good afternoon, ladies and gentlemen, again. Someone said I have a weakness. I love to greet people. I can greet and greet and greet and greet. I think that's my weakness or my good point. I don't know. But good afternoon, ladies and gentlemen. Good afternoon, ladies and gentlemen. I want us to do a small icebreaker. I believe we have oversat. We just had lunch. We are tired. But don't worry, we are going to be having our last session. But before the last session, let's all stand up. Let's all stand. You're going to do what I say, right? And who is good at doing what they are told to do, not doing what they think. Clap. Three times. You have to do very fast. Clap. Good. Clap. Shoulder. Raise. Clap. Shoulder. Raise. Clap. Thank you. Thank you. Just okay, that's stand up. So I guess Okay, we are having our last panel discussion for the day, and we shall be talking about the role of data privacy, Lawyers Association in shaping data protection practice and enforcement in Africa. Allow me welcome Daisy, who is going to be our moderator of the day.
afternoon, ladies and gentlemen. My name is Daisy Bigabwa, and I'm a member of the Forum for the Data Privacy Practitioners in Uganda. I'll be moderating this session. Please allow me to invite the panelists. We'll start with Council Ivan Ojakol, a partner at Matrix Advocates, and the chairperson at the Forum for the Data Privacy Practitioners in Uganda. We'll also have Dr. Olumide, who will be joining us. Please allow me to confess that I was challenged by your bio and inspired as well. So he gave the address earlier this morning, and I apologize that I'm not going to read it. Our next panelist who will be joining us online is Babitayo Ojo, a seasoned data privacy professional and the founder of Techlo Lab. Is it on? So welcome to this panel. The discussion is on the role of the Data Privacy Lawyers Associations in shaping data protection practice and enforcement in Africa. As most of us are aware, and just as the discussions have been from morning, data protection laws continue to emerge and mature across Africa. Legal professionals are also increasingly at the center of these laws that are emerging. So this evening, we are just going to have a brief discussion on how these associations can be able to influence policy, support regulators, and also promote compliance. In a minute, we'll start with Ivan. Kindly just help us understand how these laws are rapidly expanding across Africa, yet their implementation remains uneven. So as the different associations in Africa, but specifically Uganda and Nigeria being represented, what role should these data privacy lawyers associations play in bridging the gap between legislation and effective practice?
Thank you very much. Unfortunately, we are, as a Federation Forum for Data Protection Practitioners Uganda, way younger than what Mr. Dr. Babalola has been at the helm of in Nigeria for a very long time. But nonetheless, and that is why we came together. That's why you, Daisy, Joel, I saw Raymond, and a couple of others have come together and formed this association, because we need to fill the implementation gap. In as much as the ad-legals of this world, the Sekamwa, Mr. Frank Sekamwa and Raymond again, who are our members, have done a good job in through strategic litigation. There's still a big implementation gap. For example, the Kenyans have been meting out heavy fines and penalties. Unfortunately for us, the law does not allow our PDPO to give out those penalties. They'll just make a declaration and say there's a breach, among others, but when it comes to a fine, a monetary fine, that will not be given. So we have such challenges, and it's because of that lawyers, and not just lawyers, because this is a cross-cutting subject, all encompassing, cybersecurity experts, IT experts should come together and help bring to the fore this subject of data protection and privacy proper. Like Dr. Babalola mentioned earlier, is a cultural issue, and a lot of it will have to. Is a lot of groundwork that has to be done in creating a privacy culture in Africa. Like you mentioned, we don't even believe that things should actually be that private in Africa. We are a very communal society. So things like those, privacy by design and ensuring that the same way discussions on ESG are going on when it comes to corporate boards and what have you, sustainability is the same way the privacy subject should be at the forefront of what is happening at the corporate level. So I don't know if I've answered your question, but largely there's still an implementation gap, in as much as there's been progress right from the Safe Border report when PDPO are still under NITA to Sekamwa to Adligo, among others. There's been progress, but still there's a gap, and there's a massive opportunity here, especially with these big corporates, these big multinationals playing in our sector, on the continent in Africa, and all of these cross-border data flows that are happening, and also that now taps into the ongoing Africa regional integration mechanism, because there is no way we are going to integrate fully as Africans without ensuring that the dividend that comes from our data that these people are playing around with is properly brought home to Africa, and that now ensures that, and that now calls for us as experts, as lawyers, as practitioners to come on board and help our policymakers, our presidents, our leaders through harmonized networks, through working together, and telling them that, hey, there is this, but we can ensure that this dividend is properly brought home through us experts, through us practitioners, through us competent professionals, and therefore, please ensure that we harmonize our laws, ensure that we are at par, so that we can arrive. And I don't know if I answered the question, but perhaps I'll expand on it further later.
Okay, thank you very much, Ivan. Now, speaking of the gap that exists between the enforcement and these associations, I'm aware that the Nigerian Association has existed for more than a year. Doctor could just take us through how it has managed to mitigate this gap.
Once again, thank you for inviting me to be part of this. Honestly, I can't, Bibitayo is also watching, I can't say 100% that we've been able to mitigate these gaps. I think because we are also less than 2 years, we started maybe like April, really March last year, and we are still getting more members. But I think one thing we've just been able to do very well is we've been able to the number of members we have currently impressive, because we are less than 2 years and we have over 450 members already. That's a lot. I mean, starting from there. So in terms of gap, I think it is going to be a gradual journey. It won't just be first of all, the recognition of the role those associations play. It's important that the regulator is able to identify the roles that they play first, such that if there is any regulation or there is any legislation or as an amendment, the input of such associations can be sought, and whatever they eventually say will always also hold some water. But I think what such associations will really need to do very well is to watch the space. For example, where we've been doing that, where the regulator is meant to either issue certain directives or they are meant to clarify certain issues under the law, and they have not done that. For example, the Nigerian regulator, there are a few things that they haven't done, and we've written them few letters. Some they would respond. There is one that we're still at it. Our regulator is going to be 3 years now. This is 2026. Maybe they are even 3 years already, or going to 3 years, and they still don't have a board. The law provides that they should have a governing council, a governing board. They do not have it. We have written them, and I think we are even litigating that. I mean, from our own point of view. So where there are gaps, the ones that can be done by advocacy, yes. The ones that can be done by engagement, yes. And there are some that it is litigation that will solve it. There's a case that judgment was just delivered last week, or even early this week. Even our regulator is happy with the decision. We went to court on their powers to register point of sale. I don't know if you have something like that. Okay, you guys have POS as well, huh? POS. So in Nigeria, it's a kind of trade where you on the roadside, you see, just for inclusive banking, you have these people carrying POS and you can withdraw money from them. So the regulator wanted to register the POS. I actually took them to court, not the association. I took them to court that come from your regulation. These people do not qualify as controllers or as processors. We wanted the court to clarify it. and to their benefit, the court clarified. And I even had to send a text to the director that these are the gains that you can get from litigation. And they went to town with it. They were happy that there's a validation of what they do. And I said, if we had not litigated it, there's no way you would have gotten this validation. So the gaps will come in many ways, and it can be fixed from many perspectives. Of course, it's not everything we are going to litigate. Some will be some engagements, we have serious engagement. Some might be advocacy that we need to do around it. Some might even be articles we need to write. Some might be advisory that we need to give. And some we might end up in court. So whichever way, or whichever, after a careful consideration and analysis of what the gaps are, then we will be able to decide what's the best approach to this. So that's what I think. Thank you.
All right, thank you, Doctor. Now, like it has been mentioned that the gaps are quite many, and yet it's lawyers that are the forefront of ensuring that these gaps are mitigated. So my next question is to Ojo. In your perspective, should lawyers' associations establish minimum competence standards or certifications for privacy practitioners?
Okay, good. To know from there. Can you hear me, please? Can you just confirm the content?
Yes, please, we can.
Okay, so you just asked about whether it's appropriate to set standards. And probably before I go on, I just want to thank you for bringing on board to participate in this session, and I also want to thank my boss, who is also thank you, sir. Okay, so honestly, this is one of the ways to go, because most of us in the data protection space, we are lawyers. I've only seen few individuals who are not lawyers very great in this space, but most of us are lawyers. Well, from my discussion, from my research so far, I have not actually seen any basic standard for data protection that really regulates the professionals in the space, especially the lawyers who provide advisory to clients, to organizations, and so on. So, but in as much as there's no specific framework, or let me say a code of conduct that really regulates our interaction, our professional interaction with clients in the space. Something to find that I found out in Nigeria, I'm not so sure similar pattern work in Uganda, but in Nigeria, I know that the Nigerian Bar Association has a particular framework that guides data protection practitioners, lawyers, and a profound information I got from that document is a part where that document is actually referring to the rule of professional conduct that regulates lawyers in Nigeria under the Nigerian lawyers in Nigeria. And we started speaking to rules like confidentiality, the fact that you have, the fact that a lawyer has duty of care towards his client, and that is so profound to me, because in as much as we don't really have a specific code of conduct, there is a place where we can infer as lawyers. So that is because you are a data protection practitioner, you are not going to show care to your client. So in as much as you are a lawyer and you are bound by rules of professional conduct, then it should also translate into whatever you are doing as a data protection practitioner. And to just round it up, I also found out that IAPP also have something kind of similar in their code of conduct. There is a particular part of that code of conduct that is also related to the need for integrity, the need for care, and to also be professional when rendering services or when acting as a certified individual or identified. So I think it is very, very important that we pay attention to this. While we have this disjointed in different documents, it's also important to bring it to the limelight so that everyone can do that. You acting as a data protection officer or privacy professional advising client organization should not just be should mean that we are also functioning as professionals. So we can't just do it like that. So thank you.
Okay, thank you very much. Because we are running out of time, I'll invite Ivan to maybe just say something about the forum in a minute.
Okay. Our questions are done. Okay, so a discussion was started towards the end of last year among lawyers. Yes, unfortunately, I use the word unfortunately because I think this is an area where a subject that should cut across not just lawyers, but lawyers have been the lead when it comes to privacy and data protection. So we discussed among ourselves and decided that, you know what, the only way we are going to properly bring this subject home to Uganda is by us agreeing to work together. So we started working together. We just had a company limited by guarantee, have so far done some publications. For example, if you've read, there was a publication by Mr. Joel Peter Namugera, Patrick Mugarula, and Isaac Opio on data protection in public events, for example. We have done some publications when it comes to the US-Uganda health data sharing health framework. I think you've seen that. It was a bit controversial, it was in the news. We've done a couple of webinars here and there. But all of that is really for us to work together in order to ensure that this subject called data protection is brought home, and to ensure that our people are protected, to ensure that our businesses are protected. And beyond that, of course, we have a whole calendar of activities that are coming up. We shall perhaps have events like this. We shall have more publications coming out. We have strategic litigation lined up, among others. So we encourage you. We are working on a proper, very soon through our social media, you'll see information regarding how you can join us. So whoever is interested in joining us, please watch out for that, and hopefully we can work with you and also become as big as what Dr. Babalola is leading in Nigeria. So yeah, so we are really, really ready to hit. We have hit the ground running and are ready to even properly consolidate and solidify ourselves as the leading data protection. I don't use the word authority because there's PDPO, but the other authority outside of PDPO. Because as Dr. has said, it is only through organizations like those that if you are in the world, you can be an individual and you be a small giant. You know, when you're walking alone and you're a short man, you might think you're very tall. When you stand next to a giant, you then realize that you're actually short. So yeah, so it is only by creating synergies. And of course, we are not necessarily saying that we're going to be fighting against PDPO or be enemies or whatsoever. It's going to be a working relationship, but that does not mean, like Dr. Babalola said earlier, that we cannot call them out when they cross a line. So we also have an ombudsman role as far as the protection of data is concerned. So in a nutshell, I don't know if I've convinced you to join us, but hopefully you'll be able to join us, and that information will be out there. Thank you very much.
In a parting shot, Doctor, I just need you to just highlight on how these associations, I know for Nigeria it has existed for 2 years now. Uganda, we've barely made a year. And I know there are some African countries that don't even have these associations. So how can we work together as the different associations in Africa and not only push for data protection at a national context, but at a regional context as well?
The Kenyan counterparts, I mean, we've been talking, and we even had an event together. So I think it's a gradual process. Now, with the Ugandan, we are forging a partnership. And so connecting it to Kenya, Ghana, I think this is how movements start, actually. And I'm not in a hurry at all. I believe, I mean, it's something that will be organic. I mean, on this your event, I mean, we have close to about 4 or 5 Nigerians, or even more, participating. That's how partnerships start. And trust me, matter of time, because when we started ours too, we started with just about 5 people, and gradually, once people see value in it and they also want to become, because I mean, Africans, we discussed it, we don't joke with community. Community is extremely important for learning process, for solidarity process, and whatever it is. So I think it's conversation we will start having. I've met him. I would introduce him to the person who is succeeding me, because in few months I'm leaving. The whole idea is start something, and I'm happy that, I mean, people are taking over, and this is Bibi Tayo, who is also one of us, and who is also doing very well in his right. So I think it's an organic thing, and we can always get better. Yeah.
All right. Thank you very much, ladies and gentlemen, for listening to us. And we still encourage each one of us to be part of this movement. Do not be left behind. Thank you.
As we come to the close of the first day, I want to thank you all for your active participation. We have online attendees. I would like to thank you for attending both virtually and physically. I would want to thank the people in the systems. Thank you so much. We appreciate your work. I would like to thank those who have been here from the very beginning to now. You know, they say, to know who loves you, who cares about you, you wait at the end of the wedding when food is done. The ones who stay are the ones actually who are your friends. So you people are true friends. After the food, after the drinks, you still stayed. Thank you for staying with us. Thank you for supporting us. This has been the first of its kind. So we are making history. Possibly one day they will look back at this, and this will have created the impact we hope it's going to create. Today we started a bit late. We apologize. We spent a lot of time in the morning, so I apologize that we started late. Thank you for staying through. Tomorrow we are going to start early. We are going to try to keep time so that we give you time to go and enjoy the weekend. Thank you so much. If I want to call you specifically by name because I'm grateful. At Adligo, we are so grateful. Thank you for coming. Thank you for staying here. Thank you for listening to us. Thank you for creating time to be here. It means a lot to us, especially because this has been the first of its kind. So having you here with us, believing in us, believing in our dreams, in our goals, it really means a lot to us. Those are the guys in the systems, thank you so much. We appreciate you've been here since yesterday and now you're still here. Thank you so much. So I'm going to let you go. See you again tomorrow. You want a group photo? Okay, those who want a photo, you can come. Data privacy laws. Now, I cannot, you people have not been paying attention. Dr. Babalola talked about it. You people want to sue Adlegal. Terms and conditions. Those who want the photo, please come forward, but terms and conditions apply. Please don't sue us for image rights. There is a handsome gentleman in a blue t-shirt. So my photo will be with the guys in the systems.